of the Assembly of States parties to the Statute of Rome of the International Criminal Court for the invitation to attend and for facilitating our attendance here at the 21st session. Our congratulations are to be addressed to you for the quality of the reports presented and for all of the efforts that you have deployed to ensure that the activities of the court could run so smoothly over the last year. My delegation holds trust when it comes to your leadership and how you guide our work towards success. Like those who took the floor before me, allow me to take this opportunity to congratulate the court for progress achieved over the last 20 years. Indeed, I don't think we can ever emphasize enough the crucial role and the particular responsibility that the ICC has in moving towards a world of peace and justice. Our acknowledgements go to all of the presidents, prosecutors, judges, and registrars who have fulfilled their mandate with such commitment, and also for their absolute devotion to the struggle against impunity. Today, our support to them and to those who will be following in their footsteps is due. We would like to applaud their professionalism and the efforts that they have rolled out, as well as that by all of the staff at this international body, so as to ensure that we can find solutions to the problems that the world is facing. Ladies and gentlemen, the Republic of Madagascar shares the ideals of peace and justice that are advocated by the International Criminal Court. Our participation in this assembly is a reaffirmation of our particular interest in international criminal justice. Madagascar would also like to underscore its attachment to multilateralism, which is what led to the very adoption of the Statute of Rome, and thus stood as a turning point, a decisive turning point in establishing all of the different elements that were required for maintaining peace and security and the respect for international law. Madagascar firmly believes that cooperation among states is crucial if the court is to address its challenges, to fully fulfill its mission in the execution of its mandate for promoting, protecting, and defending human rights and human dignity. By ratifying the international instruments concerning human rights, Madagascar took full ownership of the principles such as respect and protection for fundamental rights and freedoms, the establishment of rule of law, and the elimination of all forms of injustice, of corruption, inequality, and discrimination. Madagascar places the highest possible importance to these values and principles, and I'm able to mention only, among others, just as a small hint of them, the struggle against the crimes relating to gender and those committed against children. In 2019, the government of Madagascar adopted a law concerning the struggle against gender violence, gender-based violence. Moreover, the national policy for protection of children is currently in the drafting process. Madagascar holds that, among other things, it is vital to reinforce awareness-raising campaigns and information campaigns among our communities so that they understand better and can take true ownership of the mandate of the International Criminal Court. And more particularly, we hope to reach out to our young people to encourage them to manifest their interest in employment at the court or wherever Madagascar and other underrepresented countries could play a greater role. By way of conclusion, let me take this occasion to announce that Madagascar will be presenting a candidate for the post of judge of the ICC in the elections to be held in 2023, and we would appreciate your support. Thank you.
Thank you very much for your attention. Je vous remercie.
Thank you once again.
Merci beaucoup.
Thank you very much. Now it's time to head to the Director General of the Department of International Law and Treaty in the Ministry of Foreign Affairs of Mongolia.
Mongolia, please.
Thank you, Mr. President. Your Excellencies, distinguished delegates, ladies and gentlemen. At the outset, I express my sincere gratitude to the Assembly and the Court for the hospitality and excellent preparation for the 21st Assembly of the State Parties session. My delegation commends the essential contribution made by the International Criminal Court at a global level to the promotion of the rule of law and human rights since the Rome Statute entered into force, and appreciate its commitment and efforts during the challenge we face collectively today. At the time when the rule-based international order is impending increased pressure, strengthening its criminal justice system has become even more vital. Mongolia reiterates our strong commitment for the court and its work as an independent and impartial judicial institution with universal jurisdiction to enforce accountability for the most serious crime of international concern referred to in the statute. The world we live in today is complex, uncertain, and unpredictable. The rule-based international order is facing increased challenges. The fight against impunity today is more critical than ever. We believe in the rule-based international order, and strengthening the international criminal justice system is imperative. Mongolia is firmly committed to upholding the principles and values preserved in the Rome Statute, to contribute its implementation and efforts to promote universality. In light of this, Mongolia, in cooperation with the ICC, will host a regional forum in the Asia-Pacific region in Ulaanbaatar in 2023. Mr. President, since the inception of the international criminal justice system, Mongolia has stood together with the international community in pursuit of accountability for the gravest international crimes. In this regard, together with Argentina, Belgium, Senegal, Slovenia, and Netherlands, we are working towards adopting a new multilateral treaty for mutual legal assistance and extradition for domestic prosecution of the most serious international crimes. We encourage state parties to support and join the draft convention and attend the diplomatic conference to be held in Slovenia in May next year. As a practical tool to enable states to comply with their international obligations and empower their national judiciaries, it is proposed to set a modern procedural multilateral treaty on MLA and extradition, which would facilitate better practical cooperation between states in investigating and prosecuting these crimes. Mongolia remains firmly committed to continuing its active support and partnership with the court to further activities of the ICC and strengthen the system of international criminal justice. I thank you, Mr. President.
Thank you very much. We're now going to hear from the permanent representative of the Bolivarian Republic of Venezuela.
Spanish. Señor Vicepresidente.
Mr. Vice President, Excellencies, distinguished delegates, on behalf of the Venezuelan people and our President Nicolas Maduro Moros, we would like to acknowledge the work done by the President, Ms. Silvia Fernandez de Gurmendi, and we extend our greetings to the President, to the Registrar and the Prosecutor of the Court, as well as all of their teams. And we thank the Secretariat of the ASP for all of their work. We invoke the principles of universality of this justice mechanism, which is yet to be fulfilled. And we would like to see full ratification of the Rome Statute, and we urge anyone who has not yet done so to ratify and also to maintain their obligations under the treaty. Transparency, impartiality, and inclusiveness are principles that need to be part of this justice mechanism. And it's necessary to consolidate trust in the international community, guaranteeing the exercise of justice without double standards. The Bolivarian Republic of Venezuela places the greatest importance on the court's budget and in a framework of zero nominal growth. And in this regard, we would like to call for the rational and efficient use of the court's resources, particularly given the current difficulties for our respective economies. Venezuela understands that the court needs to have the financial wherewithal if it's going to continue, if it's going to fulfill its mandate. And we have done our best to honor our commitments in this regard, despite the fact that we're suffering unilateral coercive measures. Everybody is calling for people to avoid getting into arrears, but many of them have actually supported the illegal blockade against Venezuela imposed by the U.S. The UK, for example, has significant reserves that it is withholding from Venezuela. And here in this very course, there were some sanctions that have been put against, that have been inflicted against our countries, despite the claim to uphold international respect and equal treatment, and even international organizations seem to be unable to stand up to these unilateral coercive measures. And we hope that the investigations that are being led by the prosecution concerning these measures denounced by Venezuela will be able to identify where the responsibility lies. Now, the government, through its president, Nicolas Maduro, is keeping focused on constructive dialogue between Venezuelans among Venezuelan society, and we are pleased to see the negotiations are ongoing in Mexico with representatives of our government and from the Venezuelan opposition under the auspices of Norway. And we want to thank Norway and Mexico for all of their efforts in achieving a peace and national reconciliation. Cooperation is a key aspect if the court is to reach its goals, and that is why we should avoid any politicization or interference promoted by other countries. These need to be firmly rejected, so that the sovereignty and independence of a political nature of all states is respected, and that we all take part with objectivity, equality, impartiality, and allow justice to case. Because Venezuela has been and will continue to be respectful of the rule of law, and our constitution is a cross-cutting axis when it comes to defending and protecting human rights. And we have informed the OTP and other court bodies of the way that our organs and justice system are working in guarantee of human rights. We reiterate our cooperation with the court, and this can be seen in the memorandum that was signed between Venezuela and the prosecution on the 3rd of November last year, and resulted in the new visit to the public prosecutor of Venezuela in March of this year. And and a technical visit in October of this year, and a recent visit between the Vice President Delcy Rodriguez and the Deputy Prosecutor. And we just reiterate that Venezuela and our government has nothing to hide. We are victims of a campaign against us, and there are many millions of times. Paradoxically, this has been turned into fake news. We want to call on governments to denounce the allegations leveled at Venezuela. The interventionist program that has now been resolved by decision of the people. Mr. Vice President, we reiterate that Venezuela has always respected its commitment to cooperate with the prosecutor and the Rome Statute. Furthermore, the institutions of Venezuela have shared information that is relevant concerning the status of the trials that are ongoing in our own system of justice concerning the events of 2014 and 2017 in conformity with our domestic legislation. In Venezuela, the victims will always, in our justice system, find entities that can satisfy their expectations of justice, which is the primary responsibility of any state. And questioning this would be tantamount to undermining the issue or the notion of complementarity that we think is so important under the Rome Statute. And we feel that there has to be trust in the national justice systems in our respective countries. I finally wanted to mention that we are concerned with the underrepresentedness of staff from our GRULAP region. We think that this is a shortcoming that needs to be addressed by this assembly, and the Venezuelan delegation considers that the court needs to have a balanced staff and reflect different cultures, languages, and legal systems of its member states. And finally, we reiterate our commitment to the Rome Statute and the court, and we wish this 21st session of the assembly every best outcome. Thank you.
Muchas gracias.
Thank you very much.
Mali, c'est mon plaisir de vous présenter.
I now have the pleasure of introducing the Secretary General of the Ministry of Justice and Human Rights from Mali. You have the floor, sir. Thank you very, very much, Mr. Vice President. Mr. Vice President of the Assembly of States Parties to the Rome Statute, ladies and gentlemen, on behalf of the Malian delegation that I have the honor of representing here at the 21st session of the Assembly of States Parties to the Rome Statute, I wanted to express my delegation's gratitude to Madam President of the Assembly of States Parties and to congratulate her on her tactful and professional stewardship of our work. Our commendations also go to the members of the Bureau, and we want to acknowledge the outgoing Registrar, Mr. Peter Lewis, for all of the work that he has done during his time in office at the court. Ladies and gentlemen, Mr. Vice President, it's time to recall that Mali signed the Rome Statute on the 17th of July, 1998, and ratified it by law 001 on the 29th of May, the year 2000, and submitted its ratification instrument on the 16th of August 2000, which means that it gave the ICC competency to acknowledge crimes relevant under the Rome Statute on our territory. And thanks to the law of 2016, we have been able to see the later amendments to the Rome Statute duly taken into consideration in our national law as well. Mali cooperates with the ICC not only in terms of the Rome Statute provisions, but also on the cooperation agreement signed on the 13th of February 2013 with the OTP, and the memorandum signed concerning the conditions for the ICC's presence in Mali, signed on the 5th of September 2014. Moreover, It's worth recalling the agreement on immunities and privileges signed in July 2004, and the agreement on the execution of sentences signed on the 13th of January 2012. Every time there are serious human rights violations or any serious crimes committed, then we know that we now have the legal wherewithal to deal with acts of terrorism and related crimes, thanks to the modifications made to our legislation. When it comes to rolling out the ICC's mandate, the government of Mali, in its letter dated 18th of July 2012, called upon the prosecutor at the time of the ICC to open an investigation into crimes, international crimes, committed during the 2012 crisis. Calling on the ICC to intervene sent a powerful message from Mali that Mali wanted to address the perpetrators of these most heinous crimes and also assist the victims, and meant that the abuses would need to cease and that crimes would not remain unpunished. Ladies and gentlemen, in the framework of cooperation, Mali has received requests for cooperation from the ICC, the Bureau of the ICC, the Bureau for the Funds of the Trust Fund for Victims, and the Council, the various respective council of people who are on trial. And these relate to the missions that were made possible in Mali, particularly in the region of Timbuktu. Relating to the crimes committed there. The government of Mali, through the local Timbuktu authorities, satisfied these requests by ensuring secure premises for video conferences to be held, as well as listening to victims and witnesses to make sure that these activities could go unhindered. Just by way of illustration, let me say, firstly, there was a facilitation of direct meetings between several delegations of the OTP and the Malian judicial authorities, and these meetings meant that we were able to share information on the proceedings that were open in the national jurisdiction concerning suspects that were arrested in the north of the country and transferred to Bamako by the specialized anti-terrorism unit and international organized crime unit. And that was how Mali executed the arrest warrant of the 27th of March 2019 against Al-Hassam Ag Abdul Aziz Ag Mohamed Ag Mahmoud. A second aspect of our cooperation among these two parties concerns the provision of assistance, logistics support, and security support. When the ICC came to Mali, the government provided them with security support and also provided the MINUSMA personnel with all of the support facilities that they required. When it comes to the trial currently ongoing against Al-Ghazan Abdul Aziz Al-Marad Al-Mahmoud, Mali executed requests for cooperation from the Council of the Accused when it came to addressing documents to him concerning his personal data, information concerning his detention and the cases leveled against him. Furthermore, Mali executed the request for assistance of OTP MLI 127 PPB ABRI dated 17th of June 2020 concerning information regarding two people, and a request for assistance from the 23rd of September 2020 about a transmission of copies of evidence for the information proceedings against the accused. Similarly, Mali has provided logistics assistance and security support for missions that it hosted. For example, the ICC Bureau, which was organizing an information and awareness-raising session for the public in May 2022, and awareness concerning certain sensitive judicial activities from the 27th of October to the 7th of November of this year. There was also the Trust Fund for Victims, which was able to pursue its activities with the reparations order ICCC 01/12/0115-236 concerning the implementation of the reparations through the Trust Fund for Victims. And on that occasion, the delegation was able to move ahead with the official launch of the reparations orders and continue dialogue with the community of Timbuktu. Separately, Mali was able to make 2 voluntary contributions to the ICC. One was a voluntary contribution to the court, and one was to the Trust Fund for Victims for hosting visiting families. Mali benefited from technical and human capacity building initiatives, enabling its jurisdictions and other national services to investigate, try, and sentence those who had committed offences against under the Rome Statute. But as concerns the decisions handed down by the ICC when it comes to recovery of fines or monies from fines, we are pleased to announce that we've created an agency for the recovery and management of confiscated or seized assets, as well as a modern detention centre able to hold 3,000 inmates. Moreover, a ceremony was organized by the government of Mali and the Trust Fund for Victims on the 30th of March 2021 in Bamako under the presidency of the President of the Transition, in the presence of personalities, political authorities, and administrative representatives of Timbuktu. So as to deliver a symbolic euro to the state of Mali, given the sentencing of Ahmad al-Faqi al-Maldi. Remember that the Trust Fund for Victims has a second mission, and that is of assistance. It's offering physical and psychological support and builds on the reparations program of the Commission for Truth, Justice and Reconciliation. And these reparations are being rolled out in Mali over 3 years until 2023. It's important to underscore that we are in phase with these decisions and is currently creating the updates as necessary. And these, we see them as the interfaces between the ICC and its member states, and this facilitates the fluidity and embodies and gives substance to the decisions of the ICC. When it comes to Uganda, regional balance, we think that the ICC needs to build on the expertise of African individuals, and yet for some inexplicable reason has focused more on expertise from other regions of the world that are overrepresented. But the time has come for it to use the most valuable, competent expertise that is on offer from everyone. It's about geographical balance and equality for all. And we expect this to see this called out in the upcoming elections of judges. We have the necessary know-how in Africa. Ladies and gentlemen, allow me to finish this statement by quoting Juja Sang-hyung Song, who was president of the ICC from 2009 to 2015, when he made his speech before the UN General Assembly on the 26th of October 2011, and I quote, "The Rome Statute is built on fundamental shared values, peace, security, and the well-being of children, of men, of women from around the entire world. By joining this community, each member state is contributing its stone to the edification of a rampart which will protect future generations from terrible atrocities." End of quote. I would like to build on this to reaffirm our commitment in Mali to continue in our cooperation with the ICC as part of the strict respect of the provisions of the Rome Statute. And we wish the Assembly of States parties every success in its work. Thank you very much.
Merci, Monsieur Diarra. Prochainement, nous avons...
Thank you very much. And now we're going to hear from
He's the ambassador of Spain.
Who's ready to speak? Yes. Senora, the floor is yours.
Señor Vicepresidente.
Mr. Vice President of the Assembly, high dignitaries of the Court, Excellencies, ladies and gentlemen, it's an honor for me to speak before this ASP of the International Criminal Court. I would like to begin my address by endorsing the statement made by the European Union. This opportunity makes it possible for me to reiterate my country's firm commitment to the Court as a fundamental system of universal justice and the fight against impunity. We would call on all states to sign and ratify the Rome Statute to progress towards universality. As we were celebrating the 20th anniversary of the entry into force of the Rome Statute, with the 25th anniversary of its signing just around the corner, the Court finds itself in a moment of maturity. It's a decisive moment that has its challenges as well. Let me point to some of the issues that are of special interest to my country. One of the important initiatives is the review process. On the basis of the report by the independent experts, we have had a thorough evaluation of all the recommendations, and we've begun progressing in implementing many of them. I would like to express my gratitude to Madam President of the Assembly, as well as the Vice Presidents, and all of the different mandates that fall under their responsibility in The Hague and in New York, as well as those in charge of the established review mechanism. Progress is being made in very important matters: coordination between bodies, the workplace culture, participation of victims, or processes of election. We would urge everybody to continue to support the implementation of these recommendations that have been given a positive evaluation. Moreover, we take this moment of the Court's maturity to focus on its rising amount of judicial and trial activities, with 3 parallel trials and 17 investigations in various continents. The investigation opened in Ukraine, which my country has co-referred, is facing what were hitherto unimaginable challenges. The institutions of the Court, especially the OTP, have reacted in due course, and now an investigation is ongoing in Ukraine with support from Ukrainian authorities, other member states, and other institutions like Eurojust. Spain, too, is giving its support to Ukrainian investigators and prosecutors with its own experts. They shall cooperate with the Court whenever necessary. The law must be upheld now more than ever. It's time for multilateralism to play its role, and the ICC plays a critical role in this. In any event, we believe that all situations deserve equal attention, and for every victim, we have a moral duty that we cannot leave unsettled. We would like to express our support to the judiciary and the prosecutor's office as critical elements that focus on 2 main thrusts: prevention and complementarity. In the concrete case of the prosecutor's office, we've seen progress when it comes to operational association with the authorities of the states parties and other international mechanisms. In just a few days' time, Spain shall make a voluntary contribution to the Trust Fund for Advanced Technology and Specialized Capacities at the OTP for an amount of 500,000 euros, as was announced by Spain's foreign minister. Another main thrust is cooperation. There's cooperation enshrined in the statute, but there's also voluntary cooperation. The Council of Ministers of Spain has signed an agreement for the execution of sentences with the court, and it will be signed during this assembly. We would encourage other states to take similar initiatives that lead to the practical, necessary, and effective assistance to the ICC's work. Spain would like to refer specifically to the victims. We are a country that is quite sensitive to restorative justice, and one of the main pillars of our foreign policy is to give voice and assistance to victims. As such, we shall continue to lend our support to the Trust Fund for Victims, both in terms of reparations and assistance, especially with special consideration given to women and children. I'm pleased to say that in just a few days, we shall also be making a new voluntary contribution to this fund of more than 37,000 euros on top of what we've already given this year. Vice President, I would like to take this opportunity as well to express my gratitude to all of the representatives of the court, their staff, for their dedication. I would also like to commend Registrar Lewis for his professionalism and his excellent work. We believe that the processes of due diligence and the recommendations of the Assembly will make it possible for the judges to elect a new registrar on the basis of their merit, excellency, and maximum moral character of the candidates, and also bearing in mind the importance that states parties lend to geographical diversity, gender balance, and principles of diversity and representativity that are critical for Spain. Mr. Vice President, Spain would like to conclude by expressing once again its full commitment to the efficiency of the court, and we are actively involved in all the negotiations to make sure that we can have a balanced and sustainable negotiation and outcome for its budget. Vice President, this Assembly is standing with the present and the future of the court in its hands. Please, everybody, you can continue counting on our sincere, responsible, and constructive support to make sure that the Statute of Rome ensures that no crimes go without punishment.
The Deputy Representative to the United Nations, I'm afraid I have to say one word, and that is that Ambassador Kanu is a mainstay of our New York working group. And as you all know, he's been extremely involved personally on the expert review. And Michael has done extraordinary work on all of our behalf. So I wanted to single him out today for a shout out, if that's permitted. Ambassador Kanu, please.
Thank you. Thank you, Vice President. Indeed, very kind, and thank you, state parties and stakeholders. Vice President, in the 20th anniversary year of the International Criminal Court, and at the most active period of its work, the Republic of Sierra Leone is pleased to see the return of a less restrictive format of the Assembly of State Parties, having together state parties, principals and staff of the court, civil society, and other stakeholders in this annual convocation. We commend the leadership of the court and indeed the staff for their dedication in carrying out its important mandate as an independent and impartial judicial institution, committed to uphold and defend the principles and values enshrined in the Rome Statute in the universal resolve to end impunity for atrocity crimes. This commitment to the mandate of the court is needed on a perpetual basis, including cooperating on the outstanding requests for arrest and surrender. Sierra Leone will continue to support a strong and efficient ICC and the Rome Statute system. The system of ensuring accountability for atrocity crime is founded on the principle of complementarity and interstate cooperation. For it to work, we must emphasize the strengthening of the domestic capacity of state parties to investigate, prosecute, and punish the perpetrators of crimes within the jurisdiction of the court. The ICC will step in only as a court of last resort when the state parties are unable or unwilling to do so. With the current spate of regrettable continued perpetration of atrocity crimes, the relevance of the ICC mandate cannot be overstated, and the need for continuing commitment by the state parties and other stakeholders to address accountability gaps in line with the Rome Statute cannot be overemphasized. To undertake its important mandate, leadership by and within the court is fundamental. As the Assembly of State Parties and the judiciary are in the process of electing the next registrar of the ICC, and as we agree on the need to stress, and I quote, the necessity of securing the highest standards of efficiency and competence, end of quote, we use this opportunity to emphasize the importance to accord, and I quote, high priority to equitable geographical representation, gender balance, and adequate representation of the principal legal systems of the world, while emphasizing the need for preserving diversity and multilingualism, recognizing rotation as a useful tool, end of quote. This is significant for the court to attain and to be seen to reflect the universal character to which it aspires. We use this opportunity to pay tribute to the outgoing registrar, Mr. Peter Lewis, for leading the work of the registry at a critical and consequential time for the court. We thank him for his excellent contributions, his dedication, and for implanting the sense of stability where needed the most. Vice President, following recent elections of the prosecutor and deputy prosecutors, the ongoing election process for the registrar, and judicial elections next ASP session, Sierra Leone joins other state parties and civil society in welcoming the institutionalization of a vetting process for ICC and ASP elections, where high moral character is a requirement. We therefore welcome the report by the facilitators on the third election of the prosecutor of the ICC Lessons Learned of 25th October 2022, noting that, and I quote, a large majority of state parties considered vetting to be central to the election process and consider that there should be clear rules covered in the terms of reference from the start, end of quote. We look forward to the next steps in developing the permanent vetting process in an inclusive and transparent manner. Vice President, Sierra Leone acknowledged that the court, in its 20th anniversary year, made significant progress and expanded its activities despite the challenges caused by the coronavirus pandemic, with the court being seized of 24 cases involving 31 defendants and 17 situations. Since its establishment, the court has now opened 31 cases involving 50 suspects or accused. Investigations have also been opened regarding the said 17 situations with almost universal regional spread. This is the reason why Sierra Leone supports the commemorative series of events planned for the 25th anniversary of the adoption of the Rome Statute in 2023. The extraordinary achievement of the international community in the adoption of the Rome Statute and the court is worth commemorating with the objective to enhance political support for the Rome Statute system, promote universality, and to reflect on the future of the court and the Rome Statute system with high-level discussions on the strategic vision for the next 10 years to implement Recommendation 363 of the Independent Expert Report. On the independent expert review process, Sierra Leone is pleased with the pace of the work of the review mechanism and the results achieved thus far. The review process aimed at improving the performance, efficiency, and effectiveness of the court's operation must achieve its stated aim. Sierra Leone therefore continues to urge state parties and all stakeholders to continue their support and constructive engagement as the focus shifts to implementation of the positively assessed recommendation. Vice President, in Sierra Leone's bid for a non-permanent seat at the United Nations Security Council for the term 2024-2025, noting the significant role of the Security Council within the Rome Statute system, we have prioritized the effective maintenance of international peace, safeguarding human rights, and pursuing a culture of accountability. We believe that human rights protection and promotion builds confidence in democratic governance, as well as bridge societal divides by strengthening a sense of common value and shared humanity, and at the same time promote peaceful resolution of conflicts, grounded in respect for the rights and dignity of all. Our membership in the Security Council will support the work to break the culture of impunity through engagement and action to foster a culture of accountability. We therefore acknowledge the role of the Security Council within the Rome Statute system, and in this regard, by the state parties to the Rome Statute serving on the Security Council. The Court and the Security Council indeed have, and I quote, different yet complementary roles in addressing the gravest crimes of concern to the international community, which has the potential to destabilize international peace and security. The Security Council's prerogative to refer a situation to the court can help to promote accountability in situations where grave crimes may have been committed, but the court lacks jurisdiction. End of quote. In closing, Vice President, the government of Sierra Leone, in recognition of the important work of the Committee on Budget and Finance of the ASP, nominated Mr. Sir Lahai Jusso for the one seat allocated to the African state parties, with elections to be conducted this 21st session. As we thank state parties for their support as we move towards a consensual outcome in the ASP's election of a member of the CBF, we urge this Assembly to act on the need to address the issue of the composition of the CBF as for the principle of equitable geographical distribution, rooted in the fundamental principle of sovereign equality of each state party to be fully respected. Let me close, Vice President, by reiterating Sierra Leone's unwavering support for the court as an independent and impartial judicial institution. And this restatement of support to the court is a way of reiterating our commitment to the victims on whose behalf we have this accountability system. We continue to acknowledge and commend the Trust Fund for Victims for the discharge of its critical mandate. Therefore, Sierra Leone further supports the call for, and I quote, the consistent implementation of the court's mandate across the situations and cases under its jurisdiction in the interest of justice and the victim's right to access justice, stressing the need for sustainable resources for all situations, as well as cooperating with the court. End of quote, and I thank you for the floor, Vice President. Thank you.
Thanks to Ambassador Kanu. We now will hear from the Ambassador of Kenya to the Netherlands.
Mr. Vice President, Excellencies, ladies and gentlemen, the Republic of Kenya lauds the leadership of Ms. Sylvia Fernandez de Grumendi, President of the Assembly, the Bureau, the Secretariat, and all who have worked tirelessly to ensure that the Assembly continues to fulfill its role of providing management oversight regarding the administration of the Court. Mr. Vice President, Excellencies, the review of the functioning of the Court and the Rome Statute system in 2020 marked a significant milestone in the efforts of states parties towards a more robust ICC system. The review sought to strengthen transparency and fairness by all the organs of the Court. The report of the independent experts contains numerous recommendations, both short and long-term, with varying degrees of complexity, attendant risk and costs, and urgency of implementation. Kenya supports necessary reforms to the court, but this should be done with an informed and nuanced approach to decisively tackle some of the structural and operational challenges faced by the court. For example, the proposed recommendation 367 and 370 take away from the independence and efficiency of both the Committee on Budget and Finance and the Audit Committee and related personnel. If these recommendations are taken at face value, they will negatively impact the effectiveness of these organs of the court. The report of the Committee on Budget and Finance is an integral tool for the representatives of states parties in understanding the financial position of the court. The report of the Committee on Budget and Finance has indeed in practice formed the basis for the political negotiations on the proposed budget of the court. The informed and nuanced approach to implementing the recommendations of the independent experts should also extend to the recommendations on efficiency and the protection to a right to fair trial, particularly recommendation 201 on the regulations of the court to govern a no case to answer motion. Provisions regulating no case to answer should be incorporated into one of the texts of the court. Ideally, they should feature in the rules. But until the rules can be amended, it should be incorporated into the regulations of the court. Mr. Vice Chair, Kenya will be replacing its member of the Committee on Budget and Finance, who has since been appointed ambassador to the Kingdom of the Netherlands. That would be myself. Having worked for the last 5 years and been the immediate former Vice Chair of the Committee on Budget and Finance, as well as the immediate former Chair of the Audit Committee. To complete the term that was due to end in December 2023, Kenya has conveyed as a replacement Ms. Sanyu Diana Awori. Kenya is certain that the remainder of the term will be just as impactful and urges states parties to complete the endorsement process at this ASP21. Mr. Vice President, in carrying out its mandate, the court must always be alive to the objectives set out in the preamble of the Rome Statute. Criminal jurisdiction is first and foremost the duty of every state. The court does not have the capacity to investigate and prosecute cases in the many territories where atrocious crimes are being perpetrated. It is therefore imperative that states parties, the court, and stakeholders collaborate in strengthening national and regional institutions to enable them to deal with international crimes, to ensure that there is no impunity gap. Kenya has made several strides in building its capacity to investigate and prosecute international crimes and therefore enhance cooperation with other states and foreign entities through the enactment of legislation to facilitate the investigation and the prosecution of international crimes, witness protection, mutual legal assistance, and the recovery of assets. Kenya urges the court to live up to the requirements of the principle of complementarity as enshrined in the Rome Statute. Rather than increase its docket with cases that could be dealt with more effectively at the domestic level, the court should prioritize the creation of synergies with states for the domestic prosecution of some of these cases. Mr. Vice President, the Kenya Witness Protection Agency has ensured cooperation in carrying out measures aimed at facilitating the special protection of threatened and/or intimidated witnesses to strengthen the regional and international criminal justice system. The Witness Protection Act No. 16 of 2006 provides for the special protection of witnesses at the national, regional, and international level. The need for an effective and efficient cooperation framework on witness protection and a standard operating procedure at the regional and international levels is therefore exigent. The Kenya Witness Protection Agency developed draft witness protection regulations in 2022 to provide for appropriate reciprocal witness protection arrangements with an international court, tribunal, commission, institution, or organization. The government of Kenya will continue to promote the rule of law and undertake the necessary cooperation consistent with Kenya's domestic, regional, and international obligations as a state party in the protection of witnesses. Mr. Vice President, accountability is key for the legitimacy and credibility of any institution. Kenya recognizes and respects the independence of the judges of the court and of the office of the prosecutor. However, no person, organ, or institution is above reproach. It is with dismay that we note certain aspects of the annual report of the head of the Independent Oversight Mechanism, IOM, and in particular, cases received from across the court during the reporting period 1st October 2021 to 30th September 2022. Some concern allegations of harassment, including sexual harassment and/or abuse of authority, allegations of fraud, undisclosed conflicts of interest, and one case of sexual exploitation and abuse. While there was no conclusion on the allegations of fraud that were investigated, there was at least one conclusion noting that the relevant staff member had been grossly negligent and was responsible for the loss of funds. The personnel of the court at all levels must continue to be made aware that the commission of acts of fraud and misappropriation has consequences upon both the institution and the culpable individual. Kenya would support measures to abate such conduct. The same annual report of the head of the IOM covers the evaluation of the workplace culture in the judiciary. Here, Kenya expresses deep concern with the findings of the evaluation on the existence of a perceived atmosphere of impunity and a general lack of accountability of staff, as well as underperformance. The annual report made for a startling read, and it reinforces Kenya's desire to more fully examine the management systems of the court, and particularly where there is non-compliance, poor performance and lack of delivery, or low implementation of work plans. Kenya welcomes proposals to consider expanding the capacity and resources of the IOM to enable it to investigate the conduct of elected officials and staff, including former officials. Mr. Vice President, on the back burner of all our deliberations is the perennial incremental budgetary increase proposed by the court. Kenya has diligently met its financial obligations since becoming a member of the Rome Statute and has dedicated itself to the noble cause of an international criminal justice system. However, Kenya is deeply concerned about the current budgetary proposal of the court, which is a staggering 20% growth since the last Assembly of States Parties in December 2021. The Horn of Africa is currently experiencing the greatest drought in 40 years, not to mention the brunt of the COVID-19 pandemic and the severe economic and inflationary pressures following global geopolitical events. A proposal from the court for a 20% increase in budget at this time puts states parties between a rock and a hard place. The Committee on Budget and Finance played its role in giving us a well-justified counter-proposal at 16%, but the figure remains in double digits, which is still too high. The financial demands of the court are unsustainable. Certainly, this is the time to tighten our belts and not to loosen them. And this is an opportune time for scrutiny of all activities with a view of prioritizing those activities that are critical and seminal in light of the prevailing circumstances. Cost rationalization is therefore an existential need of seminal importance. Kenya is urging the court to reorganize its priorities and cut costs in its regular budget without underfunding its critically independent subsidiary organs, such as the IOM, the Independent Oversight Mechanism. The perceived increase in the workload and activities of the court cannot and should not be the driving force for an unjustifiable increase in assessed contributions. The cost-saving measures should also not compromise the court's legal obligations to its staff and to service providers. Kenya would also caution the court against an over-reliance on voluntary contributions from states parties for non-core activities, or an open-door policy for concentrated secondments from only one regional group at the expense of geographical representation in the court. A balanced geographical representation within the court is critical for the image and the perception of its independence. Mr. Vice President, we cannot conclude without recognizing the sterling leadership exercised by the court's outgoing registrar, Mr. Peter Lewis. Mr. Lewis successfully steered the operations of the court in difficult times and remained available for consultation. We certainly wish him continued success in the future. In conclusion, the Republic of Kenya urges all delegations to engage with each other, share past experiences, and in this way build a court that will serve humanity as envisaged by the states parties. Thank you.
I thank the ambassador from Kenya. Now ask the ambassador from Ecuador to please speak.
Señor Vicepresidente.
Thank you, Vice President, distinguished heads of delegation, excellencies. I just wanted at the outset to recognize the excellent work done by the President of the Assembly, Silvia Fernandez de Gurumende, that done by the Vice Presidents, Katerina Sergontsova and Robert Ray, ambassadors and vice presidents, and also the members of the Bureau and the Secretariat of the ASP, who've all worked so diligently to make sure that this session of the ASP can be a success. I especially wanted to express our acknowledgement to Mr. Peter Lewis, Registrar of the Court, who has had a key role in the economic and administrative management of the court for the last 5 years, and whose term of office will be coming to an end in the early months of 2023. My delegation wants to wish him every personal and professional success in the future. Ecuador trusts that the recommendations stemming from the Assembly concerning the election of the incoming registrar will be of great use to the honourable judges of the court when it comes to electing the next competent candidate to the head of this institution. It's an honour and a privilege for me to represent the Republic of Ecuador in this 21st session of the Assembly of States Parties to the Rome Statute. And in this session of the Assembly, we're not only welcoming the reopening of the world after 2 years of the pandemic, but also the effective contributions as an Assembly towards various different issues of great importance, present and future, for this international body. Ecuador has always lent its support to the role played by the ICC in defending the international rule of law, combating impunity, and providing reparations to the victims of crimes under the court's jurisdiction. Being the only permanent international jurisdiction, as a jurisdiction of last resort, that is has jurisdiction over the worst crimes of international transcendence. And we want to support the essential and independent work of the court, free from any political pressure or threats that could fetter its work. Our delegation calls on member states to intensify their cooperation with the court so as to enable it to fulfill its obligations and guarantee the smooth running of the Rome Statute system, in particular when it comes to exercising warrants of arrest. Furthermore, in terms of complementarity, Ecuador places a great deal of importance on this because it enables states to cooperate in the struggle against impunity and constitutes a support for national legislation. In this regard, we're promoting the incorporation of the corresponding provisions of the Rome Statute in our respective legislations, and we underscore that international cooperation and judicial assistance are basic pillars for strengthening the effective work of the court. Mr. Vice President, Ecuador, as a country of peace, that when it comes to our internal and external promotion and respect of human relations and multilateralism, is proud to be an active member and state party to the Rome Statute. And that is why His Excellency Juan Carlos Holguín, the Minister of Foreign Affairs, just a week ago held meetings here in the ICC with the highest authorities of the court. And I just want to reiterate what was said by Minister Holguín in a personal capacity when he said that Ecuador is fully committed to holding the high-level seminar for the Americas with the ICC in June of next year, which will actually coincide with the 25th anniversary of the adoption of the Rome Statute, the aim of which is to strengthen the international criminal justice system through dialogue and exchange of best practices concerning the principles of universality, complementarity, and cooperation in the Americas. It will have a special focus on victims of crimes under the court's jurisdiction, as well as the work of the Trust Fund for Victims. I just wanted to take this opportunity to thank the court for their support in our hosting of this important event. When it comes to the governance of the court, Ecuador is in favor of strengthening this ongoing dialogue with the state's parties and civil society through the implementation of good practices and experience that we've accumulated over the years, particularly when it comes to designating authorities in the court. Ecuador has been closely following the exchanges concerning the implementation and recommendations of the independent expert review as part of the review mechanism of the ICC and the Rome Statute system. Ecuador's position when it comes to the budgeting issues of the ICC, just as in other international bodies, has been to try to find the most effective redistribution of human and financial resources so as to avoid increases. And in this regard, our country is in favor of appropriate distribution and rationalization of resource use, so as to enhance efficiencies, as well as the observance of the mandate of the Rome Statute concerning gender balance and geographical representation. My delegation recognizes the work undertaken by the court in presenting a budget for such a complex year as this one. We take due note of the work undertaken by the CBF, and Ecuador hopes that the budget that will be adopted is one that can, on the one hand, guarantee the operations of the court and at the same time take consideration of the economic realities in each of its states parties. By way of conclusion, I just wanted to pay tribute to all of the victims of the most heinous crimes and welcome the system of reparations and assistance of the TFV, which is one of the key programs of the ICC. And we hope that it can continue with its ceaseless work, which brings so much hope to those who are victims of these heinous crimes. Thank you very much.
Muchas gracias.
Thank you very much.
Señor Ministro del Paraguay.
Thank you very much. Now, the Minister of Paraguay, you have the floor. Mr. Vice President of the Assembly of States Parties to the Rome Statute, Excellencies, ladies and gentlemen, the presentation by the Republic of Paraguay that I am honored to represent is pleased to take part in the 21st session of the Assembly of States Parties. And we are celebrating 20 years since the entry into force of the Rome Statute, which is a moment of great importance for the court and for the Senate. We want to thank Madam President of the ASP, as well as the Vice Presidents for all of the work that they've done, as well as the Bureau and Secretariat of the ASP, because they've been able to work in an expeditious and professional manner and balance all of the different works that they had to do as we've come through the COVID-19 pandemic. We also know that these are very difficult economic times, and Paraguay has done its utmost in terms of balancing its books and has thus been able to meet its obligations when it comes to paying its contributions to the court. And in this regard, we are very aware of the economic difficulties in this post-pandemic world, and yet at the same time, we think that the budget that we are called upon to pass in this assembly needs to be balanced, fair, and focused on rationalizing costs and creativity when it comes to utilizing these ever more rare resources. We just wanted to thank the prosecutor Karim Khan for all of his work, which he's carried out with independence, professionalism, and a great deal of commitment. And we salute all of the progress that has been made in this last year. And also the establishment of an upcoming office. We want to acknowledge the work done by Mr. Peter Lewis as the outgoing registrar. We also welcome the work done by the CBF. We know that the work that they are doing is going to be of great importance in these difficult times for all member states. So we want to reiterate our trust in the system of that the international community wanted to create when it set up this ICC. The existence of the court is a milestone when it comes to bringing an end to the impunity for the most heinous crimes and ensure justice and reparations for victims of international crimes under international law and in keeping with the United Nations Charter, bearing in mind the importance of complementarity within the Rome Statute system. Paraguay advocates a consolidation of a broad and constructive dialogue with NGOs and CSOs, and we are sure that with such a dialogue, they'll be able to contribute to strengthening international justice and the noble objectives pursued by the Rome Statute. Finally, allow me to say that the world needs a strong, impartial, independent ICC reflecting the international community's determined determination to end impunity. Thank you.
Yes, we now ask the
Thank you.
ambassador from the Prosecutor General, of Timor-Leste to join us. Thank you.
Madam President, Excellencies, distinguished delegates, and representatives of civil society and non-governmental organizations, I'm honored to once again address the Assembly of State Parties to their Rome Statute. Allow me to begin by greeting the President and her team for the work that they have been carrying out in the Presidency and extend this greeting to the President of Court, the prosecutor and the secretary, and also to congratulate in a special way the deputy prosecutors and the election to the 20th session on the Assembly of State Parties, wishing many successes. Madam President, the 21st Assembly of State Parties is a unique and historic milestone for the International Criminal Court because in the Assembly we will symbolically celebrate the 20th anniversary of the entry into force the Rome Statute of the International Criminal Court, the only permanent and universal court which by the values it represents is fundamental for the realization of international justice. Timor-Leste, from experience, what serious international crimes and how difficult and sensitive it is to achieve justice, without which sustainable and lasting peace is not possible. Therefore, on this occasion, we would like to reaffirm that Timor-Leste is a firm defender on the International Criminal Court, is committed to promoting the rule of law, to the fight against impunity of those responsible for the most serious international crimes, and in forever of achieving justice and reparation for victims on the most serious crime against international law. The criminal accountability of those who committed serious international crimes, respecting the right of defense, and certainly an essential instrument for promoting justice and world peace, but it also implies that the use of force is prohibited and there must be no reward. Madam President, the International Criminal Court has been confronted with new and complex challenges that require response that reaffirm the values it represents. Today more than ever is fundamental that state parties remain unwavering in their support of the court and international law, and that they engage in a spirit of constructive dialogue in order to adapt the court to the needs and the challenges of the contemporary world, making it more effective and with tangible results. In this sense, the report of the independent expert presented at the last General Assembly not only identifies the challenges that the court is faced with, but also presents specific recommendations, being therefore an excellent working instrument, which must be considered by the state parties with the scope of comprehensive and constructive dialogue, a work that is the responsibility of the state parties to guarantee the condition for the court to fulfill its noble mission more effectively and efficiently. We will highlight as one of these important challenges the need for greater speed in investigation, prosecution, and trial. In this context, the recommendations are relevant and so deserve attention for the court and the state parties. The challenge of more states join the Rome Statute, materialism, the pillar of universality, cannot be separated from the reforms that in the independence expert report identifies and recommends, because only by creating the condition to make the court faster, more effective and efficient, and improving the cooperation with state parties and states that accept in jurisdiction will make impossible to give the court an even more credibility and thus persuade state not parties to join to the Rome Statute. Madam President and Vice President, allow me to conclude by reaffirming Timor-Leste's full willingness to cooperate closely with the court and to work with the presidency and all delegations so that we can achieve positive results, which at the same time preserve the independence and integrity of the court and make it more efficient and effective and contribute to match the desired universalization of the Rome Statute. Thank you very much.
Thank the representative from Timor-Leste, and now turn to the chargé for the plurinational state of Bolivia.
Muy buenas tardes.
Good afternoon, Mr. Vice President, the representatives of states parties to the Statute of Rome. On behalf of the plurinational state of Bolivia, here at this 21st Assembly of the states parties to the Rome Statute of the ICC, I'd like to take this opportunity to thank and to send a warm greetings to all participants from the President of the plurinational state of Brazil. We'd like to express our gratitude to the ICC for the good offices offered by the International Criminal Court, and we would like to also say how important we feel the objectives and results for international justice are. We're convinced that the creation of the ICC was a major step forward for international justice and the fight against impunity. However, the international community still needs to do much more if we're going to truly protect this International Criminal Court and ensure its universality. Some of the measures cases are in the hands of our governments and involve adhesion to the court's main instruments. Others, however, require collective action and consensus among states parties. The plurinational state of Bolivia reiterates its commitment to international criminal law. It has adhered to and ratified the main instruments in this regard. We'd like to recall that Bolivia was one of the negotiating states of the Rome Statute, and we ratified it in 2002. Similarly, our country ratified the amendment on the crime of aggression, and we deposited our instrument of ratification in December of 2020. Similarly, we are in the process of ratifying the amendment to Article 8 of the Rome Statute, incorporating new acts that constitute war crimes. Furthermore, the Bolivian state is party to the agreement on the privileges and immunities of the ICC, of September 2002, having deposited its instrument of ratification in 2006. We feel that it's important to inform the Assembly that the executive and judicial branches of the Bolivian government have cooperated with the court to date and with utmost willingness whenever required to do so. These facts, I think, further demonstrate our full commitment to international criminal justice and place Bolivia among the states respectful of the international legal order as a country of peace. Over and above this firm commitment, we hope that the court and its organs will continue to function in accordance with international law and, above all, respectful of its complementary and subsidiary nature to national jurisdictions. In particular, whenever there are circumstances in which cases or situations referred to the court are essentially political in nature and do not actually conform to the legal standards identified in the court's judicial practice. We are aware that the progress achieved can be furthered, and so work is being done in Bolivia in our domestic legal spheres, and norms are being discussed at various levels. And as broadly as possible, so as to lay solid foundations for the prevention and prosecution of international crimes through the Bolivian judicial authorities. This is going to be a very challenging task, and we welcome all of the technical cooperation that the court has been able to offer us in moving forward with this noble task. Bolivia also recognizes the importance of adequate financial wherewithal for the court. We feel that its budget is a vital element for fully achieving the objectives and purposes of the Rome Statute. And in this regard, my delegation supports the need to maintain current program resources. However, given these times of uncertainty and adversity, Bolivia must adopt a policy of austerity in order to ensure the effective availability of its own resources to tackle various challenges that our country is facing, as is the case with many other states parties. Bearing in mind that the International Criminal Court itself is facing challenges with and assigning high priority the election of the incoming registrar and other institutional bodies, we call on it to observe the principles of equitable and adequate geographical representation of the main legal systems of the world, as well as the need to preserve diversity, multilingualism, and gender balance. And, dear Vice President, I should like to conclude by reaffirming the utmost importance of the International Criminal Court in ensuring access to international criminal justice. We extend a warm and fraternal appeal to all states to continue strengthening the court by ratifying its main instruments so that it can become universal, and as well to continue cooperating with the court whenever necessary. The construction of an international society that is free from impunity requires our firm commitment to strengthen international institutions such as the ICC. Thank you. Halyai very much. Thank you very much.
Muchas gracias. Thanks so much.
Thank you.
All of you from the states parties. Before we continue with observer states, colleagues, I hope you will, at least one or two of you might, as well as me, appreciate a 5-minute break, very short break, help.
as well as the Bureau and the Secretariat of the Assembly of State Parties, ASP, to the Rome Statute for preparation of the 21st session. I would also like to take the opportunity to thank the judges, the prosecutor, the registrar, and the staff members of International Criminal Court, ICC, for their continued and dedicated efforts by taking an active approach toward the recent developments in international criminal sphere. Mr. Vice President, since the establishment of the International Criminal Court 2 decades ago, there are great hopes for upholding international judicial justice. However, the emergence of new challenges and threats to international human rights and humanitarian law demonstrates that the Rome Statute and the structure of the court shall adapt to the developments occurring in the international community. While the need for amendments seems necessary for more than ever, any change makes sense only if it will be in line with the fundamental principles such as complementarity, independence, objectivity, and non-politicization, and also general principles of international law embedded in the United Nations Charter, including the sovereign equality of states and non-intervention in internal and external affairs. The respect to these basic principles will promote the confidence of states to the court and its universality. My delegation as an observer and the signatory of the Rome Statute expressed its deep concern over endangering the independence of the court by certain states. Imposing sanctions against the ICC and senior officials of the court might serve as an instrument to deter the court from furthering its investigation regarding to the crimes committed by its nationals and allies. Unilateral sanctions have been imposed to put pressure on the independent actors in the international arena, which is absolutely a flagrant violation of international law. My delegation would like to recall that the Islamic Republic of Iran has been facing for years with bullying policies of certain states who impose heinous unilateral coercive measures even in the period of the COVID-19 pandemic aimed at its hegemonic policies. While it's demonstrated that unilateral sanctions are not in accordance with the international law and undermine multilateralism, it also violates the basic human rights of all people. In this connection, the Islamic Republic of Iran urges all the members of the ASP to strongly integrate their support to condemn any destructive action against the court as the core permanent institution in the fight against impunity. Mr. Vice President, recalling the political developments in Afghanistan in the last 2 years, the Islamic Republic of Iran remains vigilant to the activities of the court in relation to this situation. Our delegation is of the view that the Trial Chamber 2 decision on 31 October 2022 regarding the resumption of the investigation into the Afghanistan situation was inevitable. However, I would like to once again emphasize the necessity to have a comprehensive view of the crimes committed in Afghanistan and not merely limit the investigations to one party to the conflict or a specified period of time, which excludes some essential events in this situation. It is highly expected that those military forces who committed war crimes in Afghanistan should be responsible and go to justice. Regarding the situation in Palestine, the slow pace of work and political pressure to cease the investigation by certain states temper expectations that it may soon deliver justice. Under these circumstances, our delegation hopes the prosecutor commences the investigation in the situation of Palestine as well, while we appreciate the court's move stepping toward accountability for people involved in the century-long deprivation from their right to self-determination. We also expect the court to prioritizing investigation in this situation. The Islamic Republic of Iran commends the court's decision in starting to deal with these two situations despite political pressure and illegal and illegitimate sanctions on senior staff of ICC. We believe that the court should have the same courage in proceeding with the cases that it had in the beginning of the investigation. Mr. Vice President, in conclusion, the Islamic Republic of Iran is mindful of the international criminal justice. In this relation, the judiciary of Iran has had considerable activities in monitoring the developments and measures in international criminal law, particularly the issues related to ICC. These measures have been taken in context of empowering of ICC by its integrity and transparency in order to administration of international justice. No doubt that avoiding double standards is vital to the ICC to achieve global public opinions. Furthering the objectives of promoting the judicial justice, we are engaged with the topics of international criminal law, including the ICC-related issues, civil society, judicial practitioners, as well as the relevant scientific and academic centers have considerable participation, which include, but not limited to, participating in educational programs, research activities, and increasing publication in this field. I thank you, Mr. Vice President.
Thank you very much. I now call on the Ambassador at Large for Global Criminal Justice from the United States of America.
Thank you, Mr. Vice President. It's a pleasure to be here in The Hague with you all for the annual meeting of the ASP, and I'm honored and privileged to address you on behalf of the U.S. Observer Delegation. I want to begin by commending the Court for its achievements over the last year and for expressing my gratitude for your extraordinary dedication and the dedication of your staff. Your tasks were already legion, and your work has only become more imperative over the course of this year in light of Russia's full-scale invasion of Ukraine, but also the many other situations on your docket that deserve justice in equal measure. The impact of ICC proceedings in restoring the dignity of people is transformative. For families who are grieving loved ones who have been stolen from them, for victims of sexual violence who may have lived with a shame that more wrongly belongs to the perpetrators, for communities racked by violence. In addition to the Court's profound achievements, we commend and appreciate the tireless work of so many of you here to implement the many sensible recommendations identified by the independent expert review. These exercises in introspection and natural institutional growth are befitting of an international court now in its third decade. When I assumed my post in the Biden-Harris administration, I inherited a clear mandate to continue rebuilding the relationship between the U.S. and the International Criminal Court and to put it on a more durable path. I had a mandate to engage constructively with the Court and ASP members and to support the Rome Statute system across a whole range of situations in a manner consistent with our laws, policies, value, and enduring commitment to international justice. Over the past year, senior-level U.S. officials have interacted with the Court and ASP members in Washington and in The Hague. And just last month, a bipartisan delegation of U.S. senators traveled here for official meetings with the Court to explore the Court's work and potential areas of further cooperation. Although the United States has signed the Rome Statute, we are not a full party. Nonetheless, there is much that we can do and have done to advance the work of the Court. In the remainder of my remarks, I would like to focus on three pragmatic areas that are essential to the Court's efficacy and where the United States is uniquely positioned to help. First, apprehending fugitives and bringing them to trial is imperative of any court. The United States is proud to have played a key role in the successful transfer of 2 fugitives to the Court, both of whom were convicted of war crimes and crimes against humanity, including sexual violence. The remaining fugitives must be brought to justice. To support the execution of ICC arrest warrants, the United States is continuously updating our own sources of information and working with national authorities and the ICC to locate and strategize about how to apprehend the remaining fugitives. We are also reinvigorating our War Crimes Rewards program administered by my office, including the reward for Lord's Resistance Army Commander Joseph Kony. In this regard, we welcome the prosecutor's recent application for a hearing to publicly confirm the charges against Kony. His victims deserve the chance to bear witness even as he eludes capture. Time and again, this rewards program has proven itself to be a valuable tool, and we will continue to evaluate all situations in which offering rewards for fugitives might help to advance the ICC's efforts, and we're looking to make additional designations in the coming months. Second, The United States is committed to ensuring that all witnesses can meaningfully and safely participate in justice processes and to supporting comprehensive justice for survivors. In this regard, we are spurring a global conversation about the imperative of witness protection on behalf of vulnerable survivor witnesses, but also insider witnesses who have made the decision to testify against their former Confederates. We are pleased to deepen this conversation this week with side events co-sponsored by the ICC Registry and the delegations of Sweden and Argentina. But we all know that trials alone are not enough. Shattered communities must have the resources they need to heal, rebuild, and ultimately to thrive. The Trust Fund for Victims exists to ensure that the Rome Statute itself can deliver comprehensive justice, and we were very pleased to participate in the recent field mission to northern Uganda with the Trust Fund for Victims. Inspired by this vital work and the resiliency of survivor communities, the United States is actively considering how we might contribute to the Trust Fund, in addition to the direct support that we already provide to its implementing partners in affected communities. This brings me third and finally to the principle of complementarity. States retain legal and moral primacy in ensuring justice for grave crimes, but this can be enhanced by cooperation with international bodies. In this regard, we welcome the prosecutor's approach to building partnerships with national authorities, for example, by participating in joint investigative teams with respect to Ukraine and Libya. The United States is similarly committed to strengthening the capacity of national and hybrid courts to investigate and prosecute atrocities. In this regard, as Ambassador at Large, I have pledged to visit ICC situation countries and other societies around the world that are engaged in justice processes to look for ways that we can be helpful. In the Central African Republic, for example, there is a grand experiment in hybrid justice underway, with trials happening at national courts, in the Special Criminal Court, a hybrid institution that just issued its first verdict, and also with respect to the ICC. We commend the cooperation that is happening between the Special Criminal Court and the ICC. In the Gambia, where there are encouraging steps being taken toward the creation of a new hybrid court, following upon the successful Truth, Reconciliation, and Reparations Commission, which the United States is proud to have supported. And in Colombia, where advocates continue to forge a path towards peace and justice through implementation of the 2016 Accord, which provides for a comprehensive system of truth, justice, reparation, and guarantees of non-repetition. All of these justice innovations point to the rich lessons that can be learned from national systems and the value of deepening cooperation with regional and multilateral bodies. Yet despite these encouraging steps towards justice, we are painfully reminded of ongoing atrocities in Burma, Syria, and Ukraine, of the consequences of impunity and the imperative of the international community working in concert to secure justice. Russia's aggression against Ukraine is a manifest violation of the UN Charter. Mounting evidence reveals that this aggression is accompanied by atrocities in every region in which Russia's forces are deployed. And the information gathered suggests that these are not the acts of rogue units. Rather, they are part of a deeply disturbing pattern of abuses that we have seen with respect to Russia's prior military engagements in Chechnya, in Syria, and in Georgia. It thus falls to us to ensure that those responsible are held to account, and we commend the international community for swiftly activating a range of accountability mechanisms in the global ecosystem of international justice, including here at the ICC. Our support for these international efforts is complemented by assistance we are providing to Ukraine's Office of the Prosecutor General. We are deploying teams of international prosecutors and investigators to assist Ukraine in preparing war crimes cases. This work is part of a multilateral initiative, the Atrocity Crimes Advisory Group, that is launched by the United States, the European Union, and the United Kingdom. In short, this is complementarity in action. Mr. Vice President, esteemed colleagues, in conclusion, the United States pledges to enhance our efforts on these fronts, including through robust engagement and cooperation with the ICC and its states parties. And we encourage other friends of the courts, parties and non-state parties alike, to join us. As we have said before, the United States respects the right of every country to join the ICC. In fact, we are encouraged by the many states that have undertaken commitments to promote justice and accountability for genocide, war crimes, and crimes against humanity. We will continue to use the power of diplomacy and international law to advance justice, and we know that our efforts are all the more powerful by standing with all of you, the community of states and organizations committed to global justice. Thank you, Mr. Vice President.
Thank you very much, Madam Ambassador. We will now hear from the attaché of the Chinese Embassy in the Netherlands.
Mr. Vice President, Your Excellencies, ladies and gentlemen, it's my honor to present a statement on behalf of the People's Republic of China. China congratulates the 20th anniversary of the entry into force of the Roman Statute, as well as the establishment of the International Criminal Court, and notes the work done by the court in punishing serious international crimes over the past 20 years. China appreciates the efforts made by the court and supports the court to continue to enhance the contact and the communication with relevant countries. Such contact and communication is conducive for the court to further understand the actual situation and various complicated elements of those countries involved, and to listen to their opinions and their own choices. On this basis, and in a manner of abiding by the complementary principle of the Roman Statute and general international law, the court could play a constructive role in solving the problem properly and balance the judicial justice and the security and the stability. It is by no means easy to rebuild peace after conflict. We hope the court takes into account the well-being of the involved regions and people. China also supports the court to strengthen its interaction with United Nations, including the Security Council, in addressing the gravest crimes of concern to the international community, which have the potential to destabilize international peace and security. The court and the Security Council have different yet complementary roles. The Security Council bears the primary responsibility under the United Nations Charter for the maintenance of international peace and security, whereas the court as a judicial organ can also contribute to the international peace and security by holding the offenders accountable for gravest crimes. These two organs, under the legal framework stipulated by the UN Charter and relevant instrument, may carry out cooperation in a manner consistent with their respective mandates and the rules of procedure. Meanwhile, we note with concern that there are some debates on the issue of the jurisdiction arising from the recent judicial practice of the court. For example, in the Bangladesh-Myanmar situation, the court maintains that, here quotes, the court may assert jurisdiction if at least one element of a crime within the jurisdiction of the court or part of such crime is committed on the territory of a state party to the statute and of the court. This approach of the court imposes treaty obligations on non-state parties, which requires sufficient international legal basis to be justified. For another example, the court opened an investigation of the situation in the Philippines. It involves the obligation of the state party in its cooperation with the court after its withdrawal from Roman Statute. And it also involves the respect for sovereignty and the principle of state consent. Both need further clarification. Mr. Vice President, ladies and gentlemen, China has always supported the efforts of the international community to punish the gravest international crimes and realize judicial justice. We encourage the court to take the 20th anniversary of the entry into force of the Roman Statute as an opportunity to review and examine its own development gains and losses. We expect the court to insist the original mission stick to the principles of independence, objectivity, and non-politicization. Make sure the judicial activities of the court comply with the fundamental principles of international law, and ensure the unified standard in interpretation and application of the Roman Statute. We also expect the court to refuse political manipulation, avoid selective justice and double standard, and win widespread trust and support through practice. We hope the court contributes to the promotion of judicial justice and the maintenance of international peace and security. Thank you very much.
I thank the delegate from China. The next speaker is the Ambassador of Cuba.
Muchas gracias.
Thank you very much, Mr. Vice President. Cuba is pleased to participate in the 21st session of the Assembly of States Parties of the International Criminal Court in its condition as an observer state. We would like to express our firm commitment to fight against impunity for those crimes that have a serious impact on the international community. Mr. Vice President, Cuba lays great store by international criminal justice, but we would always uphold national criminal jurisdictions as the key element for the delivery of justice. We repeat our reservations about the broad faculties granted by the granted to the Security Council of the United Nations under Articles 13b and 16 of the Rome Statute. On the one hand, referrals to the court by the UN Security Council confirm the fact that there can be negative influence from certain political interest. And on the other hand, the suspension of an investigation or a prosecution by the Security Council flies in the face of the principle of independence that any jurisdictional body should have when it comes to administering justice. And so these elements actually hinder the proper development of a court, which should be based on these basic principles for delivering justice. Once again, Cuba would like to express its concern about the precedent created by some of the court's decisions when it comes to initiating judicial proceedings against nationals who are not nationals of states that are party to the Rome Statute or haven't even accepted its jurisdiction. The court, in so doing, must always uphold the principle of law when it comes to the consent of a state to bind itself by a treaty. This is something that is enshrined in Article 11 of the Vienna Convention on the Law of Treaties, which has been followed by states since 1969. The withdrawal of some members from the Rome Statute, of course, is their sovereign right, but we do see this trend as something that undermines the universality of the statute. Cuba repeats its position in favor of the establishment of an international criminal jurisdiction that is truly impartial, non-selective, effective, just, and complementary to national justice systems. A system that is truly independent and therefore immune to subordination to political interests that could detract it from its true essence. Once again, Cuba would like to go on record in stating its absolute determination to fight against impunity. We remain tirelessly committed to international criminal justice. We hold true the principles of transparency, independence, and impartiality. And we also uphold the boundless implementation and respect of international law. Thank you.
Muchas gracias. My information is that the representative of the Asian African Legal Consultative Organization is not here. Is that correct? So we'll go down to the International Humanitarian Fact-Finding Mission. Mr. Koutroulis.
Mr. Vice President, Excellencies, distinguished delegates, let me express first my gratitude to the Assembly of the States Parties for inviting the International Humanitarian Fact-Finding Commission to attend the travaux of the Assembly as an observer and for giving me the opportunity to say a few words. Establishing individual criminal responsibility for grave breaches and other serious violations of international humanitarian law, and setting up a permanent criminal court with jurisdiction over such crimes is, of course, among the key methods of ensuring accountability for violations of humanitarian law. But they are not the only ones. Indeed, among the means of ensuring compliance with humanitarian law are also good offices, inquiries, and fact-finding, all activities carried out by the International Humanitarian Fact-Finding Commission. The Commission is established under Article 90 of the 1977 First Additional Protocol to the Geneva Conventions. The philosophy behind the setting up of the Commission was that knowledge of the facts is the indispensable basis for the restoration of an attitude of respect for humanitarian law, for ensuring compliance with its rules. Necessary, in other words, both for achieving the peaceful resolution of an ongoing conflict and for preventing the recurrence of breaches of humanitarian law. In the age of disinformation and fake news, this necessity is more urgent than ever. The Commission is an agent of the Universal Treaty System of International Humanitarian Law. We are neither the organ of the United Nations nor an organ of any other international or regional organization. We are created by states parties to the Additional Protocol 1, and our competence is based on states' consent. So far, this consent has been expressed by 76 states, the majority of which are states parties to the International Criminal Court. We are an impartial, independent, non-political body composed of 15 experts with different backgrounds, including military doctors, medical doctors, military officers, diplomats and lawyers, acting in their personal capacities, able to take on inquiries regarding violations of humanitarian law. We are a permanent organ, predictable, ready to undertake a mission at a short notice, contrary to other ad hoc bodies. Last but not least, our confidential, flexible procedures can be shaped depending on circumstances. They thus provide the advantages of a low-key, non-confrontational approach. The Commission has proven its worth in 2017 when, at the request of the OSCE, it undertook a mission to eastern Ukraine to conduct an independent forensic investigation on an incident where the OSCE Special Monitoring Mission patrol was affected. Mr. Vice President, 65 ICC member states have formally recognized the competence of the Commission. 55 states parties to the Rome Statute are also parties to the first additional protocol, but have not recognized the competence of the Commission. We would like to encourage them to consider such a recognition. We would also like to remind all states, even those that are not parties to the first additional protocol, that they can use the Commission's good offices and fact-finding services on an ad hoc basis with all the advantages described above. Mr. Vice President, implementation of humanitarian law depends on political will. States parties to the ICC have shown such a will by adhering to the Rome Statute and thus accepting the jurisdiction of the court for the most serious international crimes, among which war crimes. They did so because, in the words of the preamble, they were determined to put an end to impunity and thus contribute to the prevention of such crimes. The International Humanitarian Fact-Finding Commission provides states with an additional complementary avenue towards what is, in essence, the same goal, contributing to the prevention of violations of humanitarian law, violations which lie at the heart of war crimes. In these times, when so much attention is given to violation of humanitarian law and to the importance of fact-finding, and in these times when symbolic acts in favor of strengthening the international legal order matter, recognizing the competence of the International Humanitarian Fact-Finding Commission and using its many capabilities enables states to demonstrate their commitment, your commitment, to ensuring respect for IHL. Thank you very much.
Thank you. We will now hear from the Committee on Enforced Disappearances. No, sorry, the Parliamentary Assembly of the Mediterranean. Mr. Roque.
I start my intervention by thanking the ICC, International Criminal Court, for the kind invitation addressed to PAM, the Parliamentary Assembly of the Mediterranean, to contribute to the 21st session of the Assembly of States Parties to the Rome Statute. Since 2015, PAM regularly attends the event organized by the ICC as observer, and I would like to extend my warmest thanks to all of you for what PAM considers as the important recognition for our engagement at your side on the issues to be discussed today. On February 21st, PAM condemned in the strongest possible terms the brutal aggression launched by Russia against Ukraine, and expressed its full support to the international community to restore peace and justice. The war has now entered the 10th month and brings with it millions of displaced and refugees, and hundreds of thousands of victims, many of them children. Almost 300 days have passed since in which we have witnessed the atrocities and the breaches of the international law and international humanitarian law perpetrated by the Russian regime, their army and their mercenaries. Based on the evidence gathered so far, and according to the UN, investigations have found that thousands of war crimes has been committed in Ukraine. There can be no impunity for war crimes in Ukraine, neither for torture, nor rape, nor systematic murder committed by the Russian forces against the Ukrainian. The impact of this invasion has put in danger the global security and stability, including that of the Euro-Mediterranean and Gulf regions. In this regard, our Assembly is following very closely, among many other issues, the consequences of the Russian aggression on arms trafficking, human smuggling, energy and food shortage, and the systematic destruction of civil infrastructures and of cultural heritage occurred in Ukraine. Not to mention the involvement of Iran, which not only violates international sanctions, but also poses a serious threat. Many PAM countries are concerned that Iran may supply the same drones used in Ukraine to armed groups in Lebanon, Gaza, Yemen, or the West Sahara, among others. Excellencies, distinguished colleagues, I wish to reiterate that PAM is fully committed to assist the efforts of the international community to, first, establish a special independent international tribunal to hold account perpetrators of the crime of aggression against Ukraine. Second, set up an international mechanism for reparation for damage, loss, or injury. Third, create a trust fund for victims of this tragic war. In addition, PAM, together with its member parliaments, is fully committed to support through its mandate the work of the ICC and reinforce further the cooperation between our organization. The PAM Secretariat shall therefore duly refer to all PAM delegations to outcome of this conference and will seek the cooperation of the national parliaments in the implementation of the necessary actions at the legislative level. I thank you all for the attention.
I thank you very much. I now turn to the International Criminal Court Bar Association. Madame Marie-Hélène Proulx.
Monsieur le Vice-Président.
Mr. Vice President of the ASP, Excellencies, representatives of international organizations and NGOs, it's an honor for me to be able to address you today as the new head of the ICC Bar Association. I was elected 1 week ago today following a campaign based on three fundamental aspects. Firstly, increasing the number of members of the ICCBA so as to give us greater weight and credibility in representing our interests and the interests of our clients before the court. Secondly, to improve transparency and communication with members. And thirdly, the continuation of the legal aid reform and improvement of working conditions for Council's support staff.
I obtained a strong mandate from ICCBA membership to pursue these overarching goals. But at this very moment, it is appropriate to focus on one of these issues: the working conditions and resources of external counsel and their teams, and the long-awaited legal aid reform, because you can do something about this at this session. You have no doubt heard about them or even seen them outside in the cold. This week, support staff in external defense and victims teams are undertaking a strike as a last resort measure after attempting to be heard for over 7 years in the registry and the ASP. They are external teams in more than one ways. Not only are they refused the status of ICC staff, but this week they have also been banned from this event in an unprecedented attempt to distance and silence them. Your Excellencies, the time is now. Until the ICC embraces the external teams representing the defense and the victims, its justice ideal will not be achieved. The chronic underfunding of the legal aid system is endangering in very real terms the right to a fair trial and the principle of equality of arms, which is a principle upon which is based the legal aid policy. I urge you to see external teams, and in particular the defense, as essential actors in the justice process, keeping in mind that parties and participants to the judicial proceedings are entitled adequate resources to competently and efficiently represent their clients before the ICC. Their current working conditions imperil their ability to effectively represent their clients. The cost of living has increased dramatically in the Netherlands, while pay has been frozen for 9 years, which means a decrease in real terms. Today, for the same work, external team members get paid at least 30% less than their prosecution counterparts, who get pay rises in line with the cost of living. This is not consistent with the spirit of the 2013 legal aid policy passed by this ASP, which meant to pay external team members fees equivalent to their prosecution colleagues. And this affects more vulnerable junior members the most, and in particular women. Unlike their prosecution chambers and registry colleagues, external defense and victims teams do not have proper working contracts, no annual leave or sick leave, no parental leave, no pension, no health insurance, and no protection from harassment, abuse, exploitation, or arbitrary dismissal. The legal aid policy also stopped the court from having geographically diverse defense and victims teams because relocation support is limited, and if team members get here, they have no social protections, discriminating against those not from the EU. The ICC budget is a complex matter, but you still have the options to improve their working conditions at this session. Legal aid for external defense and victims represent under 4% of the total 2023 budget proposed for the court, and the interim changes required can be realized within existing resources. The ICCBA urges a state to propose the resolution which will finally facilitate implementation of the IER recommendation 328, in that it first commits the Assembly to adopting a legal aid policy at its 22nd session that will ensure adequate social and labor protections to external team members, and more urgently, requests the court to take interim measures within existing resources to ameliorate the conditions of members of defense and victims teams. Excellencies, the time is now. I stand before you respectfully but firmly, alongside my colleagues, to demand an immediate and meaningful focus on this long-standing problem. External teams are proud to contribute to the mission of the court. Please allow them the resources they need to do so. Thank you.
Thank you, Madame Prou, for raising an important issue. The Coalition for the International Criminal Court, Deborah Ruiz Verduzco.
Good afternoon. It is an honor, Your Excellencies, court officials, colleagues from civil society. It is an honor to address you as the recently appointed Director of the Secretariat of the Coalition of the ICC. The Coalition is the world's largest civil society partnership advancing international justice, which for 3 decades have worked in securing the adoption of the Rome Statute, its universalization, and the consolidation of the court. The coalition is represented at the 21st session of the Assembly by nearly 400 individuals belonging to civil society organizations from all around the world, including from the 17 situations under current investigation by the Office of the Prosecutor. While you will be able to hear important statements from some of them in this debate following me, the voices of many will not be able to be heard at this session. And so I urge you to consult our website to read the positions of those who did not fit the time allocated to civil society. Our voices, in addition to being many, they are also loud and clear, with 3 very concrete messages that I have the responsibility and the honor of delivering today on behalf of all of them. First, the court needs to do more, is called to do more. The occurrence of crimes calls for more investigations, more cases, better outreach, better victim participation, and for efficient, accessible, and fair judicial proceedings. Victims want and have the right to see justice be made. There is, however, a disconnect between the needs and the resources available. This lack of resources has been made evident by the call made by the ICC prosecutor for voluntary contributions. These contributions have signaled that there is actually political will and interest in supporting the court. At the same time, the coalition warns that funding the court through voluntary contributions can constitute a severe impediment to the optimal functioning of the court. Voluntary contributions bring risks in terms of fund management and the burden that it creates, threatens the sustainability of the court, and if those contributions are earmarked or selective, they can erode substantially, in effect or in perception, the impartiality and the independence of the court. Only assessed contributions can benefit all organs, all programs, all activities, and all situations that come before the court. The CICC joins the states parties that have called for these sustainable resources in the regular budget, and those who urge the Assembly to make a connection between the budget and the discourse that claims to be victim-centered. Certainly, an important complement to sustainable and substantial funding is ensuring that the court is accountable for the resources and their management. The implementation of the recommendations approved under the review mechanism, including with involvement of civil society, will be key to enhancing trust in the court's administration and strategic organization. Second point of civil society. The quality or capacity and moral character of those appointed to serve the court, in particular its judiciary, is central to the legitimacy of the court. As the Assembly is preparing for a new judicial election at its next session in 2023, the coalition will redouble efforts so that states parties commit and actually elect the most qualified candidates who should be nominated through public, transparent, and merit-based national nomination processes, as the independent expert review has recommended. The coalition has and will continue to strongly oppose reciprocal political arrangements or vote trading in ICC elections because of the impact it has on the legitimacy of the court. For this 21st session, we call on the Assembly to agree on the next steps for developing a safe, transparent, comprehensive, and permanent vetting process of the candidates. The credibility of the court relies on your commitment. Number third, we must remember the conditions in which civilian populations in situation countries find themselves. Many of them are undergoing armed violence, displacement, and the dire conditions that those bring. Within these already complex environments, there is also a worrying and exacerbated trend of shrinking space for civil society. And in this limiting environment, human rights defenders and activists face aggravated challenges in their efforts to bring justice to victims and in interacting with the court. We welcome the many statements made yesterday and today at the general debate by those states parties who recognize the work of human rights defenders in advocating accountability. Mr. Vice President, in light of the Bureau mechanism implemented as part of the Independent Expert Recommendation 169, we invite the Assembly and the Court to engage with the coalition to advance the necessary policies that enhance the political, legal, and physical protection of human rights defenders in their interactions with the Rome Statute organs. To continue with this urgent conversation, I invite you to join us tomorrow, Wednesday, at a side event at the lunchtime to learn about the challenges that the defenders face, and what can the Assembly and the states parties do independently to support them. To build on this point, the coalition reiterates and appreciates the unique consultative status that we have with the court and with the Assembly, which builds on earlier recognition of civil society in the final act of the Rome Conference in 1998. Looking ahead to 2023, which coincides with the 25th anniversary of the adoption of the Rome Statute, and symbolically also with the Declaration on Human Rights Defenders, the Coalition for the ICC stands ready to continue working towards our common objective of universality and implementation of the Rome Statute, to continue help strengthening the court, protecting its integrity and independence, and its relevance in realizing the Rome Statute promise of ending impunity for perpetrators of the crimes that shock the conscience of humankind. Thank you.
Thank you very much. We now turn to the Libyan NGOs. Is there a representative here? Oh, there she is. Yes, please come forward. Yes, hello.
Thank you, Vice President. حضرات المندوبين الموقرين والزملاء الأعزاء، يسرني أن ألقي اليوم كلمتي أمام جمعية الأطراف.
Ladies and gentlemen, I'm delighted to address you at the 21st session of the Assembly of States Parties to the Rome Statute on behalf of Lawyers for Justice in Libya and our partner NGOs. This is a particularly difficult time in Libya. For more than a decade, without any tangible progress on the Libya file, the Office of the Prosecutor took some promising steps this year, including publishing an updated roadmap for accountability in Libya, establishing a more regular presence in the region, and the submission of new applications for arrest warrants. However, local trust in the ICC is at an all-time low. This is a result of years of lack of tangible progress, minimal engagement by the ICC with victims and their families, and civil society actors, as well as the ongoing crackdowns of Libyan civil society and the failure to address this. The meeting between the prosecutor and Khalid al-Haftar one of the greatest criminals allegedly under the Rome Statute crimes in Libya, has further damaged trust in the court and willingness to cooperate with the OTP. Distinguished delegates, responsibility to ensure greater efforts to improve the work of the ICC falls on the court and all its bodies, as well as states parties, so that the resource availability, but also efficiency within the court to deliver its mandate to the Libyan people is made a reality. And we urge states parties to provide the court with adequate resources, including budget increases, in order to enable the court to continue to prioritize and make noticeable progress in the Libya situation. Budgetary procedures should be transparent, they should be needs-driven, and that activities that enable the court's mandate towards victims, as enshrined in the Rome Statute, to be realized. Moreover, the ICC needs to continue to raise awareness among the local populations as to how important victim participation is, and this cannot be underfunded and overlooked. In this regard, the court needs to take a more active effort to ensure adequate outreach, and we urge the court and states parties to systematically condemn attacks and reprisals against Libyan civil society and call on Libyan authorities to ensure a safe and enabling environment for their work. The court has a duty of care to CSOs and that are facing risks as a consequence of their engagement with the court. There is little to show that Libyan authorities currently have the capacity or the will to deliver meaningful justice, and the court, as well as states parties, should demand genuine cooperation with Libyan authorities, which should go beyond welcoming official visits, and it should include tangible efforts to secure the arrest and transfer of suspects to the court. And this also means enabling the courts of safe and unselective access to all victims and affected communities. Crimes against humanity and war crimes need to be investigated, and we call on the OTP to ensure that this is done. Crimes against humanity and war crimes against migrants and refugees in Libya, with a view to prosecuting those most responsible before the court, is a necessity. Domestic investigation prosecutions by European authorities, as well as the joint team, should not replace but rather complement ICC investigations so as to ensure prosecution of Rome Statute crimes not currently investigated in domestic courts. Thank you.
Thank you. The representative for Colombia Diversa, who is Ms. Maria Susana Peralta.
Now it's on. Thank you. Your Excellencies, my fellow colleagues of the civil society organizations, good evening. As everyone may have noticed, Colombia Diversa, where I work, is the only participant organization from Colombia during this assembly. Not even the Colombian representative is here. Well, this is not a coincidence. We are the most desperate. LGBT persons are not safe in my country, and violence committed against them during the armed conflict remains unaddressed and sometimes even justified. Poor articulation and complementarity with the ICC will hinder our efforts to create a feminist and queer-inclusive transitional justice. Before I ask for something, let me explain. Colombian civil society has been profoundly let down after the convoluted closure of the preliminary examination in Colombia. We're happy to pave the way and be the trailblazers for new methods of complementarity and participation, but civil society must be an active part of it. We were blindsided a year ago with the announcement of the 6-page MOU, and we remain in the dark. There are no substantial arguments about the Colombian situation that justify closing the preliminary examination with such an inarticulate, exit strategy. We need more from you. How is the OP going to evaluate significant progress on criminal investigation, on victims' participation, on the search of disappeared persons, on the design and implementation of reparations? What are the standards for the investigation, judicialization, and reparation of gender-based violence committed against women and LGBT persons? We are working in Colombia Diversa to successfully litigate the first ever gender persecution case against LGBT persons before a transitional tribunal. We believe this will offer a comprehensive and complex view of what happened during the war, that it will enrich the definition of gender, that it will strengthen the queer and feminist alliances, that it will make visible hundreds of stories that remain untold, that it will reshape the definition of punishment, harm, and participation. We also hope that this litigation strategy will be a platform for other feminist and LGBT transitional justice initiatives around the world. Now that the gender persecution policy paper is being launched, we believe there are several collaboration opportunities arising. So here's what I wanted to ask. It is a big ask, but it is worth it. Create a substantial follow-up system for the MOU. This doesn't have to be an effort from scratch. We had already been working on it with the OP from 2019 to 2021. They were benchmarks that would indicate significant progress in the judicialization of sexual violence, forced disappearance, victims' participation, and transformative reparations. Colombian civil society is wounded, but we are still looking for ways to cooperate and insist on the relevance of the universal jurisdiction and jurisprudence produced by the ICC. Without a follow-up system, we will have disconnected yearly visits and ethereal signals that won't help victims get justice. And we will lose the alliance built between the ICC and Colombian civil society that has existed since 2004. I am asking you to make things differently. In Colombia, we are used to set the example, and we will gladly make sure that it is worth it for others. Let's create an exit strategy that is useful for victims, for the ICC, and for the story we want to write about justice and about human kindness. Thank you.
Thank you very much. An important message. Philippine Coalition. Sorry, I forgot it. No peace without justice. Excuse me. Allison Smith.
I'm here. I'm here.
Good.
Thank you.
Go ahead.
Thank you, Mr. Vice President. Excellencies, distinguished delegates, dear colleagues. It is an honor for me, as No Peace Without Justice, to address this assembly, also on behalf of Al-Haq, Human Rights Watch, the International Federation for Human Rights, Parliamentarians for Global Action, and the Ukrainian Legal Advisory Group, to share with you some reflections on the issues of the court's budget. As you know, civil society, among others, has consistently raised the issue of the court's resources, not only as a means to conduct their work effectively and efficiently, but also in the context of guaranteeing the independence and integrity of the court. In advance of your discussions on the 2023 budget, we wish to reiterate some points that our organisations have been making throughout 2022, especially following the opening of an investigation and the ongoing crimes allegedly committed in Ukraine since 2014. Our organisations welcome the strong show of support for the court's role in Ukraine, believing that not only will it advance victims' rights to access justice, but also that it represents an important vote of confidence in international justice in general and the ICC in particular. And we call on you to show the same level of enthusiasm and support across all situations. Our organisations also call on you to keep your commitment to international justice in mind during the negotiations for the 2023 budget. To that end, we wish to make 3 points for your consideration in advance of the budget discussions this week. First, while the boost to the OTP's capacity is welcome, more attention needs to be paid to what this means for the rest of the court. The OTP has been described as the engine of the court, and indeed is its main cost driver. Better investigations and prosecutions inevitably lead to increased needs in other areas, including victims' participation and reparations, outreach, witness support, legal aid, family visits, court management, interpretation, and everything else that goes into ensuring a fair trial and a process that is meaningful for victims and affected populations. These are also areas that have been significantly underfunded in the past, to the detriment of the court's overall performance and the ability of the rest of the court to support and enhance the work of the Office of the Prosecutor. This should be reflected in the 2023 budget and feature prominently in the budget negotiations to that end. Second, we wish to stress that voluntary funding for any part of the court's work and the provision of gratis personnel should only ever be considered an extraordinary measure. Voluntary contributions are not a sustainable funding model, as we have seen from other international courts. They risk damaging the perceptions of the court's independence, and they are inherently susceptible to the vagaries of political priorities. Reliance on these methods of support may seem alluring, but they carry too great a risk for the future sustainability and operations of the court, not least in terms of perceptions of prosecutorial and judicial independence. Finally, a word on the 2023 budget more generally. As mentioned, the call from the prosecutor for additional voluntary resources demonstrates that the 2022 budget was simply insufficient for the court to carry out its work, even without the addition of a new high-profile investigation. We therefore strongly recommend that the budget discussions for 2023 should have in mind not only the approved budget for 2022, but the fact that the court needed voluntary contributions and gratis personnel to undertake the investigative work it has managed to undertake this year across all of its situations. The situation this year demonstrates clearly that what was requested and approved at the end of last year does not reflect the real costs of the court. We ask you bear this in mind during your consideration of the overall 2023 budget request. Equally, we ask that you take the opportunity at this Assembly session to lay the groundwork to reframe discussions around the court's resources with a longer-term focus on sustainability and the real investment necessary to live up to our collective aspirations for the court. I thank you.
Thank you very much. The Philippine Coalition for the International Criminal Court.
Thank you, Mr. Vice President. Excellencies, fellow justice advocates, ladies and gentlemen, good afternoon. I come from a situation country, the Philippines. In an attempt to thwart the process of the ICC, starting with a preliminary examination then announced by the prosecutor in 2018, the then President of the Philippines withdrew from the Rome Statute. This took effect on 17 March 2019. But since then, since the start of the ICC process, the UN High Commissioner on Human Rights submitted a report on the human rights situation in the Philippines pursuant to a resolution of the UN Human Rights Council. And there has been and since then, there has already been an authorization to commence an investigation of crimes against humanity in the context of the so-called War on Drugs campaign, albeit a deferral request by the Philippines. There is also an ongoing UN Joint Program on Human Rights to provide technical assistance to the Philippines to address the justice and accountability issues. In short, the ICC process have pushed the Philippines to improve its domestic process. But in the meantime, victims and their families of the war on drugs remain waiting for justice to actually happen. The ICC has given them hope that justice will find its way to them soon. But the road to such attainment of justice must be clear and not be seen as merely illusory. The issue of resources for the ICC has been a perennial one. It is a real concern for situation countries, especially for thousands of victims, placing their hope on the ICC to get the justice that they deserve. From our experience, thousands of victims are waiting for the process of the ICC investigation to begin. It is their vision of hope for justice. But although participation is essentially made available at the different stages of the proceedings, information of when and how they can do so come mainly from civil society actors who actively seek out and bring the information to the victims or their families themselves. We do recognize that the reach of the organs of the ICC is limited due to resources made available and the capacity to reach out. But this in itself goes against the very notion that victims must be at the core of the ICC system. The unfortunate reality is that not only are they at a loss as to what to expect and the next steps given the limited reach of the information, if not the lack thereof. More concerning actually are the security risks they continuously face in relying on a system which at the same time may leave them exposed and vulnerable. We have often heard that justice delayed is justice denied, and justice for many victims we represent have already been denied at the domestic level. With hope and reliance on an international justice system, the credibility of the ICC depends on its responsiveness to deliver justice and protect the victims and their families in their quest. Resources must simply be made available to the court to ensure its success. Thank you, Mr. Vice President. Thank you, Your Excellencies.
Thank you. Thank you. We'll now hear from the Palestinian Center for Human Rights on behalf of Al-Haq, Al-Mizan, and PCHR.
Thank you, Mr. President, Vice President, colleagues, ladies and gentlemen. We have been waiting, for a quite long period of time to reach the ICC. We exhausted legally all the legal remedies within the Israeli legal system, and we found, after years and years, that they are genuinely unable and unwilling to bring to justice those who are suspected of committing war crimes. We looked to universal jurisdiction, and we tried many parts of the world, especially Europe, and we were blocked after some successes here and there, politically motivated. And we found the ICC the last resort for justice and dignity for the victims we are representing. Palestinian-Israeli conflict, one of the most well-documented conflicts in the modern history, and the need for accountability, it's obvious, and the voice very clear-cut by international human rights organizations, by Palestinian human rights organizations, and by Israeli human rights organizations as well. Palestine signed, ratified the Rome Statute and became a member in 2015 January. And we were having great hopes in the ICC, but in March 2021, the investigation was opened. And we thought it's a time really for active investigation, for real work to bring justice and dignity for the Palestinian victims who suffered war crimes, crimes against humanity, persecution, and apartheid. Unfortunately, this investigation moved nowhere, almost no millimeter, though we showed in a clear-cut way our willingness to cooperate with the investigation. We do have the files, we represent the victims, and we have the contacts with the eyewitnesses, and we are the ones who are on the ground. We felt nothing, and this wasn't really a healthy sign. In this year, 2022, it was one of the worst years ever in the history of occupation. More than 200 people has been killed by the Israeli belligerent occupation, among them tens of children. 6 organizations has been designated as terrorist organizations. They are defending victims and they are representing them, and they have all the evidence and files to represent to the ICC. And the accusation of doing lawfare. They are misusing international law. They are resorting to ICC and harboring terrorism. Nobody bought that except the Israeli state. Israel never ever in its history allowed any investigative body to go in. Any investigative body from the UN never ever allowed, neither rapporteurs or anything. Now, we look to see what Mr. Prosecutor did, in this period. Once again, we feel nothing really has been improved. At the time this is happening, at that part of the world, at the time Shireen Abu Akleh, the well-known journalist of Jazeera, being assassinated, at the time Israel do these war crimes, at the time this year is the worst ever, we find silence from the prosecutor, and at the same time we see in Ukraine very hyperactive movement for the prosecutor and his office, which is fine and make us very happy. But as Ukraine needs ICC, needs Rome Statute, need the intervention of this respected and prestigious and effective court, Afghanistan needs it, Colombia needs it, Palestine needs it as well. The Palestinian-Israeli conflict, it's one of the cases where all international human rights organizations in consensus about the need for accountability, Palestinian and Israeli human rights on consensus about that too, but we are seeing, nothing once and again moving in this direction. That's why we really calling for the ICC prosecutor office to move promptly, swiftly, effectively in this direction. Definitely, we are in need for the ICC, and we consider it as our backbone in bringing justice and dignity to victims. But as Palestine in need for the ICC in need of Palestine to restore its credibility, independence, and to show determination that this is the court for no man's court, and justice and dignity for victims irrelevant of race, religion, nationality, color, or geographical area is. We are so determined to keep cooperating with the ICC. We are so determined not to give up and to use the rule of law. We are so determined not to lose hope how hard the situation there is, and we will keep our strategic optimism and the fight till the accountability one day be seen and being tangible, and victims once again see justice and dignity. Thank you, Mr. President.
Thank you. Thank you very much. We're now going to hear from the International Federation for Human Rights. Mr. Sapu.
Excellencies, I have the pleasure of speaking at this 21st Assembly of States Parties on behalf of the International Federation for Human Rights, FIDH in French. Our organization brings together 188 NGOs from more than 110 countries, including the League of Electors, of which I am the honorary president, and that is active in the Democratic Republic of Congo. I was involved in clandestine activities under the regime of General Mobutu, and it was at that time that I co-founded in 1990 the League of Electors. And since then, we have been active in promoting human rights and the defense of victims of injustice. The investigation in international crimes in Eastern DRC was opened in 2004, and that was the first investigation carried out by the Office of the Prosecutor. The court played a key role in fighting against impunity in DRC with 3 verdicts against Thomas Lubunga, Germain Katanga, and Bosco Ntaganda. And since then, we are monitoring subsequent developments. 2022 marks the 20th anniversary of the court. It was a year that saw many promising developments, especially on the judiciary front, with the opening of new investigations and cases, but also when it comes to structural reforms and changes of strategies and policies following the first recommendations issued by the independent expert review. But the court is facing growing challenges on all fronts. The capacity of the ICC to fulfill its mandate hinges strongly on the cooperation of states parties. But that remains a permanent challenge, especially when it comes to the failure to execute arrest warrants that are still pending. The FIDH, therefore, would like to recall before this assembly just how important it is to actively cooperate with the court, but also to provide it with support by granting it the adequate resources based on true needs. We call on states parties to adopt a 2023 budget that is consistent, that will enable, in particular, the bodies in charge of effectively implementing victims' rights to carry out their necessary activities. The FIDH and its member organizations are alarmed at the current state of or lack of participation of victims in the procedures before the court. It is with regret that we've noted that some of the recommendations of the independent experts when it comes to victims' rights still receive a negative assessment, and many of them have been reassigned to the registrar. It is of particular concern that the victims have no systematic means of participation in and being duly represented when their interests are at stake, in particular during the preliminary phases of procedures, but also during the reparations phase. Necessary means must be given to the ICC so that it can provide for swift and effective reparations to all eligible victims and improve on the delays and inconsistencies in procedure that we've seen in the past, such as the case of my country, the Democratic Republic of Congo, where victims are still waiting. And some of these victims, once again, have been victims of armed groups yet again, including Movement 23 troops in eastern DRC. Unfortunately, our organization continues to see many missed opportunities of having meaningful exchanges with civil society. Often, such contacts are limited or selective. The work of the court would be strengthened by devoting more time and resources to engaging with survivors, as well as with civil society, not only for carrying out investigations and prosecutions that can be effective, but also in the areas of awareness raising and outreach, as well as for the development of broader policies within the ICC. This assembly must recognize the efforts that are being done, the vital work that is being done by civil society for many years to document violations that are serious violations of international law under security conditions that are often quite difficult. They work also supporting victims, and they fight against the impunity of the authors of the most heinous crimes. States parties must commit to providing the appropriate conditions for civil society to work in full independence with the court without hindrance. We would urge the ASP to do everything in its power to guarantee that the victims are placed at the very center of this ICC's procedures. We reiterate the need to stand as a common front in order to give the victims the justice they deserve. If we want to continue work for justice for victims, but without the victims and the civil society organizations that support victims, there is a true risk that the lack of legitimacy and credibility would become a reality. Thank you.
We have four more speakers. The Afghanistan International Federation, the International Federation for Human Rights, Mr. Seppu. The Afghanistan Organization for Development of Human Rights. The Ukrainian Legal Advisory Group on behalf of Ukraine. The Coalition de l'Afrique francophone, and the Georgian Coalition for the ICC. So that's 5. You just spoke. So that's 4. Afghanistan, please.
Bismillah ar-Rahman ar-Rahim. Excellency Vice President, ladies and gentlemen, it is my pleasure and honor to be part of this great assembly. I came from a war-torn country, Afghanistan, which catastrophically fell to the Taliban extremist group on August 15, 2022. The fall of Kabul to the Taliban also sent shockwaves through the international community, as it was the end of the US and international forces' 2 decades presence. After the Taliban came to power, the people of Afghanistan experienced disastrous conditions. At least half or more of the Afghan society's population are women, who are housebound, secondary schools for girls are closed, extrajudicial killings continue, human rights are violated, and there is no freedom of expression. Simply put, the people of Afghanistan are deprived of basic rights. Recently, there have been widespread protests worldwide to prevent the genocide of the Hazara people in Afghanistan. whereby people have protested in front of the ICC while is trending the hashtag Stop Hazara Genocide. This act has reached millions across the globe, resulting in people taking it to the streets, rightfully chanting hashtag Stop Hazara Genocide. The first half of 2022 has seen hundreds of Hazara people killed and many more injured as a result of the targeted attacks. This includes the bombing of Hazara educational centers, places of worship, hospitals, and other centers. This trend is likely to continue. There have been massive attacks aimed purely at genocide against the Hazara in Afghanistan. Hazaras are in urgent need of protection in line with international obligation under the Genocide Convention. Excellency Vice President, ladies and gentlemen, Afghanistan was the second Muslim country and the first SAARC member country to officially join the International Criminal Court in February 2023. This was positive news for the people of Afghanistan who had been suffering from war crimes, crimes against humanity, and genocide for more than 4 decades. Thus, expecting a strong international mechanisms that can finish the culture of impunity, and hope that the war criminals and perpetrators of the crime of genocide will be brought to justice. However, thus far, no practical action has been taken to implement the above. The prosecution of war and genocide criminals has not been actioned. Even the official investigation has not yet started in Afghanistan. Although on 23rd October of this year, Pre-Trial Chamber 2 of the International Criminal Court, ICC, authorized the prosecution to resume the investigation into the situation in Afghanistan. This will be the beacon of hope for the people of Afghanistan, which I strongly welcome and encourage. Nevertheless, it is not enough. As a woman from Afghanistan, I hope that the investigation proceed as soon as possible. My request from ASP is to please kindly support the International Criminal Court both financially and politically for it to be actioned as an international mechanism to deal with war crimes, crimes against humanity, and crimes of genocide in the world. As a result of bringing stability so that no criminal can escape from the law. Lastly, I would like to ask the ICC to pay serious attention to the war crimes, crimes against humanity, and the crimes of genocide in Afghanistan that is unfortunately taking place actively and thoroughly. As a civil society that has a long history of mentioned issues, we are ready to cooperate with the court in building on the foundations of long-term stability. Afghanistan is unable to investigate and prosecute atrocity crimes. Therefore, the world must step in. The Taliban must be held accountable as they are blatantly disregard their crimes. But I am confident that the international community will not. Thank you for your attention.
Thank you very much. A very significant message. Now I'm going to hear from Nadia Volkova from the Ukrainian Legal Advisory Group on behalf of the 5 a.m. Coalition.
Excellencies, distinguished candidates, dear friends. I represent Ukrainian Legal Advisory Group, and it is an honor to address you today on behalf of Ukraine 5 a.m. Coalition. As some of us sat yesterday at the launch of the annual report by the Office of the Prosecutor, our phones flashed with notification of air raid alert, followed by the messages of the loved ones. Looks like it has started. And what started was another missile attack by the Russian Federation on Ukraine. It was not so much a surprise as another missile attack by the Russian Federation was expected by everyone as a follow-up to the earlier 23rd November attack, when yet another people died and the country was plunged into the worst blackout to date. However, the pain, the suffering, the fear, each and every one of us has been experiencing for the past 9 months is still overwhelming and real, and there is no end to it in sight. Although everybody understands that this war will run its course hopefully sooner rather than later, a question remains: how much more pain can we endure? Is it measurable? Probably not. Can it be reduced? Difficult to say, but it can definitely be offset and made a little more bearable. Lessons can be learned, and future suffering can also be prevented. And the only solution to that is effective justice. So what should it look like in the case of Ukraine? The armed conflict has been ongoing since 2014. Its drastic deterioration in February this year was, among other things, due to the failure to ensure that justice that had been delivered was effective. We believe that now we are given yet another chance to put things right, even though the stakes are a lot higher, not only for the victims of the war in Ukraine, but for the benefit of those bearing the brunt of the war in other situations too. There are a few basic ingredients that form the basis for the recipe for the effective justice. 1, Ukraine must ratify the Rome Statute. For many years, civil society in Ukraine and outside has been fiercely advocating for ratification because it seemed like a right thing to do for any state that respected the rule of law. Now it must do it out of necessity, because lack of ratification undermines effective cooperation of the domestic authorities with the ICC, thereby adversely affecting the effectiveness and efficiency of the work of the court, which is so vital now. The international community, in particular states parties to this assembly, could and should put more pressure on the government of Ukraine to make this critical step towards ensuring justice, especially in light of Ukraine's EU candidacy status. It has become clear over the years that Ukraine's government is unlikely to make this step voluntarily. But a proactive position of the international community, like it has been with anti-corruption reform, for example, can indeed be very persuasive. 2, Ukraine should amend its legislation to ensure effective investigations, prosecution, and adjudication of core crimes in accordance with the international standards of due process. 3, there is an urgent need for specialist knowledge and skills among investigators, prosecutors, and judges, which Ukraine critically lacks. While there is a lot of gratitude for the steadfast and continuous support and assistance provided by the international community, large gaps remain in respect of capacity of domestic authorities needed to tackle the scale of grave crimes that are being committed on a daily basis. This is why we insist on identifying the needs of the justice system first, before any sustainable and long-lasting solutions can be offered and further discussed. And to that end, we concur with the position of the prosecutor Khan voiced yesterday during plenary and then reiterated at the launch of the OTP report that setting up new institutions as a solution to the problems before attempting to strengthen the existing ones is not an effective approach. We are going to speak more about it on Thursday at our side event. In conclusion, a patient who has flatlined cannot be resuscitated or rehabilitated by putting band-aids all over their body. Ukrainian situation needs to be looked at and analyzed holistically and not in isolation, whether it is vis-à-vis justice elements or other international mechanisms. Many colleagues from other conflict situations are now looking to Ukraine as an example of effective justice. Let us not disappoint them and make sure that justice is not a myth, but a real possibility for all. Thank you.
Thank you. Coalition de l'Afrique francophone pour la CPI.
So now we've got the Coalition for Francophone Africa.
Coalition de l'Afrique.
The African French-speaking coalitions for the ICC, or AFC-ICC, is an African structure for consultation and for defining a strategy in order to create synergy in favor of international justice and the ICC on the African continent. Its members are present in French-speaking African countries, and they are very active in the situation countries. Given the time available, our statement will focus on the situations in Guinea, Central African Republic, Côte d'Ivoire, and the Democratic Republic of Congo. Starting with Guinea now. 13 years after the events of the 28th of September 2019, the opening of the trial has now occurred, giving rise to much hope for the victims and the fight against impunity. For the moment, the trial is proceeding normally. However, in order to ensure that this hope is actually not in vain, the AFC-ICC demands that, firstly, that Guinea's partners accompany the process by honoring their financial commitment. Secondly, that the Ghanaian government takes measures to ensure the safety of victims. And thirdly, that the ICC Prosecutor's Office monitor proceedings in Guinea. Secondly, the CAR. With regards to the CAR2 situation, which has been pending before the ICC since 2014, the AFC-ICC is very concerned about the lack of urgency at the ICC to move the case forward within a reasonable time frame. The real alleged criminals are still at large and have not been arrested. Some of them are walking quite freely in Bangui, including those that are in the government, while others are abroad. And in this regard, the ICC should play the cooperation card with states. For the arrest of individuals from Seleka, it's necessary to go beyond those who played second fiddle and get hold of those who were in the commandment. The ICC must therefore avoid applying any double standards. Thirdly, Côte d'Ivoire. After the acquittal of Charles Blé Goudé and Laurent Gbagbo, the victims are still waiting for justice. As for the broader population at large, they are impatient be actioned. Secondly, we're calling for the prosecutor to provide the results of the Côte d'Ivoire 2 investigation. And thirdly, that the ICC increase the resources and budget for both the investigations and for the local Abidjan office. Fourthly and finally, the RDC. The news in the DRC is dominated by the war in the east of the country, including insecurity in almost all border areas. And given this atmosphere of conflict, the AFC-ICC is calling for the implementation of transitional justice mechanisms so as to bring peace to the DRC. The AFC-ICC believes that the Office of the Prosecutor must clearly show concern about the rise of impunity, and, above all, it should be able to reassure the victims and condemn the perpetrators of violence and crimes. Ultimately, the credibility of the ICC and the rule of law in Africa will depend on the court's ability to respond to and to manage victims' expectations of justice. Therefore, investing in justice today means saving money tomorrow, not only in terms of money, but also in terms of human lives. Thank you.
En écoutant la coalition géorgienne.
Now we'll be hearing from the Georgian Coalition for the ICC and Georgian Young Lawyers Association. Ms. Tamar Oniani, you have the floor.
Hello, it is my honor to address you today. My name is Tamar Oniani and I represent Georgian Young Lawyers Association as well as Georgian Coalition for the ICC. I'm also one of the representative lawyers of more than 300 victims of the August war before the European Court of Human Rights. First of all, I would like to send my condolences to the Ukrainian families and everyone at the global level who encountered the gravest results of the international crimes. More than 14 years after 2008 August war, the consequences of the international crimes committed back then are still impacting victims' lives today. As you know, about 28,000 ethnic Georgians have been displaced and 20% of Georgia remains occupied by the Russian Federation. The victims and the communities living in the conflict zone are subject to the ongoing persecution in the villages along the administrative boundary line to the occupied Tskhinvali region, South Ossetia. And this fact was once again attested by the recent Council of Europe Secretary General's consolidated report, which says that human rights challenges persist in the conflict-affected areas in Georgia. The situation is further aggravated by the fact that the victims' rights have not been restored, nor the justice have been served. After 14 years from the war, what we recently received is only 3 arrest warrants issued by the Pretrial Chamber in June 2022 against the representatives of the separatist regime and not against the officials acting on behalf of the Russian Federation, while the involvement of the Russian officials and the degree of their participation in 2008 August war is confirmed by the numerous international institutions. Now, it is critically important for these decisions to be executed in a due manner in order not to have the victims' hopes disappointed even more. The victims live in unbearable socio-economic conditions in the places of the resettlement and near the administrative boundary line. The grave housing conditions, the non-existence of the employment opportunities, impossibility of the agricultural work, lack of medical services, lack of income-generated activities, and educational opportunities are especially problematic. Now, I want to speak about the Trust Fund. According to the information disseminated by the Trust Fund, The program is addressed for the victims of 2008 August War who live in the IDP settlements as well as living on both sides of the administrative boundary line. However, as it seems now, the program covers only rehabilitation direction and there is not a focus on the support of the improvement of the livelihood conditions and income-generated activities, which is more than essential for the victims now. Therefore, the main call of my speech today is first to enhance the cooperation for the execution of the arrest warrant decisions, and then to support the trust fund in order to have income-generated activities for the victims of the August War. Impunity for Russia for all these past actions accumulated in gravest crimes now in Ukraine, so maybe it is time for the international justice system in general to find more effective ways out than it did in the past, and also more effective ways how to provide more victim-oriented justice system. Thank you for the attention.
Thank you so much for your thoughtfulness and your eloquence and your full participation in this discussion. The world is in a difficult place. I think we all understand that. And the defense of human rights around the world in a number of different causes is a constant challenge for us. But I think the main thing for us to do is to use the time that we are here in The Hague and looking at our budgets and looking at what we might be doing and how to go forward and what resolutions we want to pass over the next couple of days. I think it's really important that we use this time to have a very candid conversation about where we are, because the budget situation is difficult. I know many of you have expressed deep concern, and I get that, but all I can say is nothing is perfect. And we have to look at how many delegates are we going to get around a particular proposal. And that's something we all have to work hard on as we hear each other out. And this really is my last point. I think it's so important that we just listen to each other. Just try to understand where exactly are people coming from? What exactly is, and how do people deal with some of the contradictions that exist in the dialogue? Some people taking exception to this or wanting to emphasize something else. It's very, very tricky, but it's exceptionally important because we desperately need a budget, and we need a consensus on the budget. And we also need to agree on how we're going to go forward in a number of human rights areas and other areas that are extremely significant for all of us. So maybe that's not definite enough for any of you, but I just think it's not easy. We've got to move forward, and we really do have to get something going with respect to the resolution, the budget, the approach that we're taking to a number of challenging issues, and it's tough, and it's not going to be easy. But certainly, speaking as one of the vice presidents, we're committed to working with everybody, listening people out, hearing what's possible, trying to work through the issues, trying to use our colleague Beatrice is working on the facilitation for the budget. There will be other different movements underway on resolutions. Sometimes we'll disagree, and that's not an impossible thing. It happens. But I think that we all realize the extent of the crisis that we're in and the difficulty and the challenge of the human rights situation that's in front of us. So thank you all very, very much. I'm adjourning this, and we will be meeting tomorrow on other issues, and we really look forward to continuing to participate. Thanks so much. So I'm not going to go to, I'm not going to